Enforcement Review. I'll start again. Welcome everyone to the November meeting of the Citizens Law Enforcement Review Board. Secretary, if you could please take roll. Here.
Vice Chair Miriam Pinjor.
Here.
Secretary Monica here. Dr. Riley Brown. Here. Here. Nadia Pinarello. Here. Ariana Federico.
I believe she's going to be here at 6 o'clock. She had a conflict.
Okay. Where? Yeah, I will. Here.
Thank you very much. Next agenda item is public comments. Opportunity of members of the public to address the board on any subject matter that is within our jurisdiction. Oh, excuse me, but not on our agenda tonight. Is there anyone? Yeah, go ahead, Mr. Parker.
Chair Delaney will call Mr. Yusef Miller.
Good evening, everyone. My name is Yusef Miller, the Executive Director of North County Equity and Justice Coalition, the Saving Lives in Custody campaign. And what I want to discuss is several things, but one of them is a request for investigation into the juvenile detention center where 4 youth overdosed on drugs. They had to be sent to the hospital and they had to be checked in. One in a row, these people had to be sent because they overdosed on drugs. Thankfully, they lived. But we need to investigate and see how are these drugs getting into these secured facilities. We have secured facilities in jails and our youth detention centers. In LA, several months ago, I think it was either early this year or late last year, a youth died on drugs in the detention center. We don't want that kind of press. We don't want that kind of news from our detention centers. Please, I put in a request for it, and hopefully that we'll hear some news from looking into what's going on in the juvenile detention centers. Secondly, the period that it takes to get the critical incident review reports, it is a long time. It takes a long time. And I know there's laws coming out from the passage of SB 519 that says that these reports should be released in a timely manner. But please understand the time it takes for a family who's just been impacted by in-custody death. The time it takes for them to get all the data is longer than the statute of limitations. Please look into moving the statute of limitations to state or something to the effect that once a family gets the last document or all the documents, that statute starts. It takes 1 year or plus. Remember the case of Elisa Serna. She died in 2019. She just got the critical incident report in 2023, 2019. And the family got the critical incident report in 2023. So these cases affect families. For one, Gilbert Gill, the father of Kevin Mills, AC Mills, him and his family trying to get information on their son's death. Kevin Mills in jail. In the system, they had the wrong date of birth. They had the wrong name. It took them a while to circumvent the system, them telling them this is the correct person, this is the correct date of birth. By the time they got all that straight, it was a year plus. And now they're talking about you're beyond the statute of limitations for this young man who's lost his life. And lastly, in my last few seconds, the medical reporting. I know we're trying to get a hold of having jurisdiction over medical reporting, but we have people who are being medically neglected in jail. I'm working on a case right now, and we do not want another Elisa Serna to happen. This person survived, and thankfully, this person and their family can testify on what is going on in this jail system. In the Title 15, they are entitled to proper health care, and there's supposed to be an annual audit on them, not even set by the state, but there's an annual audit on the jails and under Title 15. Please read that. Thank you.
Thank you. Next, we'll go to, we don't have any other in-person requests to speak, so we'll go online to Tom Packard. Dr. Packard.
Yeah, can you hear me? Can you hear me?
Yes, sir. Can you hear us?
Yes. Yeah, my name's Tom Packard. I'm a member Showing Up for Racial Justice, North County. A recent UT article noted that a state audit and a growing number of jail deaths led to the sheriff introducing a costly 10-year plan to upgrade the jails. Your recommendation to have sheriff staff search or scan all persons entering detention facilities should have gotten more attention in the sheriff's plan. I strongly encourage you to not just wait for a response to your recommendation, but that you explicitly insist that the sheriff conduct and share with you a thorough assessment considering implementing this policy using industry-wide best practices and a detailed cost analysis. According to the UT, one recent lawsuit asserts that deputies have tolerated illegal drugs in the jails. Another lawsuit has been filed on this. You found that the sheriff was partly responsible for the Bousman jail death. At least one deputy has been arrested for drug possession on jail grounds. Millions of dollars are paid out in lawsuits, and that should be a sufficient motivation for change. And as you know, a grand jury report has also made this recommendation. There are multiple costs to consider, from additional screening equipment to changes in staff time to go through screening, analysis costs, training and supervision. On the other hand, there are likely to be huge cost savings from avoidance of paying millions of dollars from lawsuits related to drug-caused death. Please don't accept the sheriff's response that there's no evidence that staff are bringing in drugs when they clearly don't have the data to support their lack of attention to this problem. As former President Reagan put it, trust but verify. Please encourage the sheriff to devote resources to do a comprehensive cost-benefit analysis of this proposed policy so that an ultimate decision will be evidence-based and benefit the county. Thanks for your attention.
Thank you. Next, we will go to David Settles. Mr. Settles. Mr. Settles, are you?
Yes, can you hear me?
We can now. Go ahead, sir.
Yeah, okay, yes, thank you for letting me speak. I'm out of town, so I'm on my phone, but I did want to dial in once again to represent my brother, Matthew Settles. I've spoken before, and my brother passed away at George Bailey in August of 2022. So it's been a little over a year. So I'm here representing my brother. I'm here representing my family who loved Matthew, my brother, my mom. We all want to see improvements in the jail so that what happened to Matthew doesn't happen to the other families. He had mental illness. He wasn't treated while he was transferred to George Bailey with no medical support after being removed from a county mental hospital where he was being treated. We still don't have answers. So we're looking for the transparency, for the improved treatment of the mentally ill, for the other families, for stopping drugs from getting in the jail. So I just wanted to show up. I will be listening. Thank you for letting me speak, and the work you're doing here to help improve these the conditions in the jail. That's appreciated. Thank you.
Thank you. Next, we will go to Karen Remus. Ms. Remus.
Can you hear me, Mr. Parker?
Yes, ma'am.
Thank you. Good evening, CLERB members. My name is Karen Remus, and my pronouns are she, her, and hers. During last month's CLERB meeting, Mr. Parker spoke about two different situations that he was aware of that cannot currently be investigated by CLERB because there was either no complaint filed or a complaint had been filed but was done so anonymously. He then raised the possibility of board members filing complaints in circumstances like these so that CLERB could conduct an appropriate investigation. CLERB members, you are charged with increasing public confidence in and accountability of peace officers employed by the sheriff's and probation departments. From Mr. Parker's statements at the last board meeting, it sounds as though there are currently incidents going uninvestigated due to procedural roadblocks. This neither increases public confidence in nor accountability of law enforcement. Tonight, I urge you to heed Mr. Parker's advice and begin having a board member file a complaint themselves when situations such as those described by Mr. Parker last month arise. Please cut through the red tape to ensure accountability. We are relying on you. Thank you for the opportunity to address you this evening.
Thank you, Ms. Remus. And before we go to the next speaker, further information about what she just brought up will be detailed in item number 8D tonight. Next, we will go to an in-person speaker, Ilka Weston.
Hello, and thank you so very much for having me. I really appreciate all of you being here. I do want to bring up some issues that I find very concerning, and I'm so thrilled that all of you are working for solutions, and you can count on me to be a part of that. I was very disturbed to find out that the homeless were being pre-arrested, booked, and then let out again. I heard this from deputies. This is criminalization of our homeless and houseless family in San Diego. It could happen to anybody. I know it's happened to me when I have been ill, and creating a record, which will eventually go to a felony where we cannot, and I'm not an expert on the police issues, but I do know when somebody is booked 3 times for loitering, 3 misdemeanors, it turns into a felony. We need to protect our homeless and come up with solutions and not criminalize them. The other thing I wanted to bring up is we need to come down harder on Kelly Martinez to allow Narcan to be allowed in our jails. Many groups have approached her on this issue. We're having deputies sneaking drugs into the jail, and that is of grave concern, not only to me, I would believe anybody that has a soul. In addition, I want to echo in Yusuf's words that a year is not enough. I suffered a loss after standing up for a young Hispanic kid, probably about 18, who was harassed by 8 police officers. That officer, one of them, looked at me and said, "I'll come after you next." He did. I'm still suffering from what I went through. Now, did I fix it? Did I bring it to a complaint to the police station? Was there any criminal charges against me? No. Was I under the influence? No. But 1 year does not explain all the things that can come after that point, not just psychologically, physically, and for families. And we really need to look at finding a way to have extension. And when I heard my dear friend Yusuf speak on that and how I feel about what he is doing, it reminded of that incident in my life. So it can happen to anybody that you're in the elevator with. So thank you very much for listening to me, and thank you again for being here.
Thank you, Ms. Weston. And just before we go to the next speaker, in reference to the second item that Ms. Weston brought up in reference to Narcan in the facilities, Sheriff Martinez has allowed and actually has the deputies in the facilities have Narcan. And not only do they have Narcan available to them, so too do the incarcerated person population have access to Narcan. And my understanding is that access alone has saved, I don't even know how many lives thus far, but it has saved some lives. So I want to clarify that before we go to the next speaker, if that's okay. Next, we will go to Sunday Weddle.
Hi, good evening. Can you hear me?
Yes, ma'am.
Hi, my name is Sunday Weddle. I am a member of the North County Equity and Justice Coalition Saving Lives in Custody campaign. I typically speak on the in-custody death of my son, Saxon Rodriguez, but this evening I'm speaking on behalf of Kevin Mills and the Mills family. Kevin Mills died in Central Jail on November 11th, 2020. The details of Kevin's death and the lack of care and concern, both for his mental and medical, at the hands of San Diego sheriffs is good cause to reopen the Mills case for further and more detailed investigation. There are many inconsistencies that leave so many questions unanswered about how and why Kevin Mills died while at Central Jail. Furthermore, I believe there should be no statute of limitations or deadline to close in custody death cases, especially when it is the police that are investigating other police. That is a huge conflict of interest, and that is the current protocol. The family of Kevin Mills deserves a proper, thorough review of his case, and all related evidence, documents, and reports should be handed over to the Mills family. All of the in-custody death families deserve answers, truth, transparency, and closure. And lastly, I would like to say to Kelly Martinez, she needs to stop making excuses as to why she refuses to scan and search all the deputies and staff who enter and exit the jails. There are still too many near-death drug overdoses and Narcan deploys within the jails. The Attorney General needs to step up and shut her operation down and expose the truth. And lastly, I would like to say justice for Kevin Mills, justice for Saxon Rodriguez. May they rest in peace, and thank you. That's all I have to say.
And thank you. And in reference to those comments, in closed session tonight, this board will be considering two policy recommendations that specifically deal with additional on top of what we've already recommended about drugs entering the facility. So we'll report out on that at the end of this week in our final findings report. Next, we'll go to Paloma Serna.
Hello, thank you, board member, for letting me speak once again. My name is Paloma Serna. I'm the mother of Elisa Serna, who died November 11, 2019. I am also part of the North County Equity Justice Coalition. And so I also would like to shout out for Oscar Leal, L-E-A-L, who died on February 28, 2018. I would like to get an update regarding his case. His family they have the right to know what happened to their son. The ME has classified his death as a homicide, and still we haven't heard anything about his case. And it's a shame that the San Diego Sheriff would reject the ME's finding. It just shows how they refuse to take accountable for the deaths of our loved ones. And also too, I would like for answers for Matthew Settles and Kevin Mills' family. With Kevin Mills, we had just celebrated on November 11th. We celebrated together, the death of our loved ones, because Kevin Mills died a year after Elisa had died. Also, too, I would like to get an update on Patricia Adamson, who died on May 3rd of 2023. We haven't heard anything about her case also. Was her next of kin notified? If not, I'll be her next of kin. I want her to get justice. I don't want her to be forgotten. And also, too, I want to echo what Sunday Weddle, Kelly Martinez needs to stop making excuses. We need to continue to put pressure on the San Diego Sheriff and scanning all people that enter the jail, not just the inmates and their visitors, but all employees. Also, too, how convenient, that the sheriff did not perform a body scan on David Omar Ornelas. So, he could be blamed for overdosing on drugs. Still, the deputies let drugs come, into the jail. People need to be held accountable for this. And also with the CLERB report, we need to continue to fight to get those released immediately. Also, too, we need to eliminate the statute of limitation. It's so unfair for the families that we can't get names or evidence, reports, videos of people who, especially deputies, who are accountable for, to be held accountable. The sheriff's department needs to start releasing names and handling business. Clean house. Thank you very much.
Thank you, Ms. Serna. And in reference to a couple of the comments made, as far as Ms. Adamson and Mr. Settles, we don't have materials from the department yet. I believe we're still awaiting the medical examiner reports for both. As far as Mr. Neal and Mills, we did investigate both of those deaths. I don't have in front of me what the outcome was, but I can always report back at next month or in the executive officer report or somehow sooner. Actually, I can just reach out to Ms. Cerna and give her answers to where we were and what our final findings were on that. And I believe that that's all I have to address. That is what was said. Next, we'll go to, well, it says Zoom user. If you could identify yourself when we bring you over. Hello, are you there?
Yeah. Can you guys hear me?
We can. Can you, before you start, you mind identifying yourself just for the record?
Joe Guzman Jr.
Okay, Mr. Guzman, thank you. Your 3 minutes.
Yeah, I was actually incarcerated in San Diego County Central Jail, and there was a lot of discrepancies I had with the investigation of my case. You know, during my time there, I was strip searched by several individuals, you know, and you guys said that they had a right to strip search me. Well, I think that you guys are crossing the line when there's 4 or 5 people watching me get naked rather than 1 or 2. You know, I find that to be well beyond reason. And regarding to a lot of the drugs in the jail, I was also subject to watching a lot of drug dealing that was going on between inmates. And a lot of it is actually coming from the medical staff that's giving it to inmates, and they're not properly monitoring how they're taking the medication. They're handing it through the door in the jail, and then those inmates are hiding the drugs, and then that's how you guys have a lot of the overdoses, you know. And then there's another discrepancy I had in my case where you guys said that, oh, something about like you're allowed, you know, two sets of clothes and socks and you know everything that you guys issue. But when I was strip searched, they took those items from me, and so therefore I was only given the overshirt and the pants, and I was put into a cell where, you know, there was piles of trash, there was flies, there's feces on the ceiling, on the walls, and you know the staff won't even step inside of these rooms. But when you request to have an inmate come clean them, they ignore your request. And then when you file complaints, they don't turn in those complaints, and you have to ask for those complaint slips because they're not actually in the commons area where they're supposed to be. And then those cops, they're sitting there, the deputies, and they're throwing them in the trash, and they're not signing them, and they're taking them from inmates. So the whole process is just extremely messed up. And you know, I can go on for several more minutes, but I just don't feel like the way that things are being investigated is proper in any way, shape, or form. I mean, I was court ordered to receive medical, and I was denied that, and I got sick in a dirty cell and was on lockdown for 23 hours and not able to take showers every day. You know, and this is the United States of America. It's a disgrace to our flag. And you know, I'm just mind boggled at the things that I saw in there. And I've been dealing with, you know, post-traumatic stress disorder after leaving that, and have also been acquitted of all charges that I had leading up to my arrest as well. And so, you know, I just implore you guys to, you know, show some accountability, you know, get some control over medical staff, and, you know, have someone else collect those complaints.
Sorry, Mr. Guzman. Unfortunately, the time had expired. In reference to some of the comments made by Mr. Guzman, we will be providing an update on the medical service provision or providers, the jurisdiction over them in item 8C tonight. And I did fail to mention when Ms. Cerner was speaking that we have in closed session tonight 3 additional policy recommendations pertaining to the Critical Incident Review Board reports and the timeliness and the content thereof. Next, we'll move to Michael Cerna. Mr. Cerna.
Yes, I would just like to say thank you for letting me join tonight. Also, thank you for all your tireless work, for all that you guys are doing. But also, I would like to echo what everybody else has been talking about, Kevin Mills, and also the Settles family and Settles case. And these things are because the first thing with that I learned was that Kevin Mills was not given the proper attention that he needed because of a clerical error that was made in his booking. Now, this wasn't the family's fault. This was the county's fault. There was a clerical error. So why should the family be denied justice? because of something that the county made a mistake in. Why was it pushed away, looked away at until uh, the expiration time for the investigation was up? These are the same old tactics that we find happening over and over again, that they kick the can down the road until the statute of limitations are up and we have no course of action. We're done. We're out of it. It's just bully tactics. And we're finding out at the firsthand, our family, uh, through all the investigations that they've done, because through these last 4 years and everything, how they love to let the expiration time go expire and just leave families in the dark. I think this should be opened again. Once again, I believe it was your first case back, Paul Parker, when you first came back, that you looked into Kevin Mills's case. I think it should be opened again, and I think this family deserves. We recently, like my wife said, we shared a moment, and it was horrible. It was horrible to have to see the family and hear the stories, how his brothers and his sisters and his mother and his father, they're all suffering, and they're there without answers. It's like it never ends. Why? Because of a clerical error the county made. I think this is a shame. And that's all I have to say. Thank you.
Thank you, Mr. Serna. Next, we'll go to Matthew McNulty. Mr. McNulty.
Hi, I'm a victim of kidnapping, labor trafficking. Back around 1990, the trafficking organization murdered my family and kidnapped me in Hawaii. And around 1993, they transported me to San Diego. And since that time, the employees of the San Diego Sheriff Department have been perpetrating the labor trafficking conspiracy. In uniform, they are degenerate street criminals who have infiltrated a law enforcement agency. Many of them smoke crystal meth, and many of them kill sex slaves and eat their bodies on a regular basis. They're perpetrating the Jeffries Taylor labor trafficking scheme. That is the generic high IQ labor trafficking operation. And intertwined into it is a generic religious fundamentalism terrorism attack, the standard royalist censorship psyop, and a standard operating procedures communist combat psyop. If law enforcement fails to immediately rescue the victim of labor trafficking, the deception narratives of the labor trafficking scheme facilitate and cause school massacre, sex trafficking operations, targeted murder sprees, home intrusion, murder, robbery sprees, and major crime armed robbery sprees. It's the standard scheme that everybody knows about. And the employees of the San Diego Sheriff Department have made no attempt whatsoever to rescue me or to in any way whatsoever intervene in the labor trafficking scheme or the psychological warfare attack. Instead, the employees of the San Diego Sheriff Department have been positively perpetrating combat psyops in public so that their clandestine expeditionary army can get away with skull-fucking American school children, murdering their families, stealing their residences, and robbing and murdering wealthy Americans. I have reported this stuff to all the law enforcement agencies with jurisdiction. I have filed complaints with their internal affairs or corruption hotlines units, and I have filed complaints with this citizen oversight board. And so far, you have failed to do any sort of oversight response. And so I'm now just saying in public, I am an innocent victim of labor trafficking. I've done no wrong. The labor trafficking scheme is a combat psyop too. The employees of the San Diego Sheriff Department are the culprits. They are openly waging war upon the United States of America. Meanwhile, I have done no wrong. I have done nothing wrong. I have done my part to stop their crimes by reporting their crimes and filing complaints. Meanwhile, the sheriffs continue conspiring to skullfuck school children.
Thank you, Mr. McNulty. Your time has expired. Next, we will go to Dr. Fishman.
Good evening. Yeah, thank you. Darwin Fishman, he, him, his Racial Justice Coalition of San Diego. Want to thank you for your work. And I also want to encourage you to keep doing what you've been doing. I noticed that one of the things that CLERB has done is the press coverage for dealing with drug overdoses and holding the sheriff's department accountable for the conditions in jail. And it's a logical step given the record amount of in custody deaths we had last year. And I only wish you could have done this earlier, but those are the kind of steps that need to be taken to put the pressure on the sheriff's department. Put another way, if you take that kind of tactic and they see that you're holding them responsible for drug-related deaths and they're not getting away with just simply blaming people for drug overdose, but they're being held responsible for the conditions in the jail, as you've heard from previous speakers, they're aware of who's bringing in the drugs, they're aware of the drug distribution in the jails. We know that. You can talk about this in closed session. The reason why you know it is because it's on camera, they film it. And I've heard them talk about this. That kind of pressure is what's going to be effective. I really appreciate the families coming, impacted families coming to remind you at each of your meetings about the cost and the toll this is having on people across the spectrum. This notion that the people that are in jail deserve this treatment or that it doesn't need to be taken seriously is the fundamental problem we have. As you know, even with the policies in place and the new laws we've gained from Atkins and from Weber, we know that unless there's fundamental changes from the way that the sheriff's department thinks about the culture and the way they run the jails, we're still fighting an uphill battle. So I appreciate the work that you guys are doing, appreciate the path you're taking, encourage you to get even more involved in things like ATI, the Alternatives to Incarceration. We have a town hall in January, Juvenile Justice Commission, and the part about being responsible for jails that juveniles are in too, and making that known. I think it's really critical, and also holding a high standard for the conditions and what's done in the jails. So thank you for your work, and you can see the community support you have for the direction you're going in. And you can see that as much as the sheriff's department will try to not take responsibility, not respond to the policy recommendations you have, that shouldn't stop you from keep doing that. And you can also make it public. You can do press conferences and press releases too for your work. So hopefully you'll continue to find these new tactics and strategies to apply the pressure that will finally change the conditions around in the jails. Thank you.
Thank you. In reference to the press conferences and press releases, that is part of our communication plan. And if we get additional staffing to move forward with our community outreach efforts, that's one of the things we were looking to do. Next, we will go to Olivia Gutierrez. Ms. Gutierrez.
Hello. Hi, can you hear me?
We can hear you, ma'am. Yes, ma'am.
Hi, my son is incarcerated in juvenile hall. He's had several incidents to where he's been attacked by the guards, up to 9 to 15 guards for one kid to take him down. Is uncalled for. My son has been, I have pictures of all of his bruises, his scrapes, his bumps, all of his injuries, and nothing's happening. They need to come up with a different way to take these kids down. Like one incident, my son was trying to walk away. He wanted to, it was supposed to be rec time. He didn't want to go to rec. He has like something in his file to where if he needs a timeout, he can take a timeout. He was trying to go to his room. He was walking away. The guards ran after him, threw him into the TV stand because he was trying to walk. He didn't want to go outside for rec because he was having a bad day. I mean, like, why are they using this force on these kids is like beyond me. Has nerve damage in his thumb, which has never been addressed. They lied to me and said he's had x-rays. Never had x-rays. I have tons of notes. I've kept notes because I can't do anything. I call and complain. Nothing gets done. I finally found you guys, but still nothing's getting done. It's ridiculous. I don't know what to do anymore because, they're just going to cover their asses. They lie. It's just uncalled for. And I wish you guys could really do something about them beating up these kids. I mean, it's uncalled for to where it's just ridiculous. to where it takes 15 grown men to take down one kid is uncalled for. Like, I don't get it. I mean, he's been pepper sprayed, like that works. Why can't they just pepper spray him? Not that I want him to get that, but like instead of beating my son up, pounding his head into the ground is ridiculous. I'm sure my son is so screwed up when he comes home. It's gonna be like we're gonna have to deal with a lot of stuff. I'm telling you, I don't know what to do, and I just want help. So yeah.
Thank you, Ms. Gutierrez. Next, we will go to Tasha. Tasha.
Can you hear me?
Yes, we can.
Okay, awesome. Thank you for allowing me to speak. I want to echo what the mom before me is saying, because we have gotten a cause of which you also have complaints regarding juvenile hall, the new facility. I'm concerned that probation is not necessarily on the radar of anyone, and that there are children that are under their control and care that are being harmed. And I'm not sure what the answers are, but I am sure that children going into a facility should not come out worse coming out of that facility. I know that children that are in that facility having death threats, being allowed to beat other children to the point that they are injured significantly. This is not something that is acceptable, regardless of why they are there. It is something that needs to have attention brought to it, because there have been multiple instances where community members have asked for meetings of the probation chief, who is new to this county, and it has been refused. And so someone who is coming into a county should be open to meeting with community members to find the pulse of where the trust or issues or solutions may come from, because it is clear that probation has kind of tucked their tails and decided that they're going to, not all of them, but most of them, seclude themselves and not be available to accountability. To have countless community members call me about their children that are being harmed in a juvenile institution is shocking. It's shocking. When we put millions of dollars into this institution, one, to build a new one, and two, to change the atmosphere and the environment so that these children could come back to our community healed and whole. And that is not the case. And so I feel like this is a waste of taxpayer dollars, and that there has to be some more eyes and accountability placed on the probation department, especially the new juvenile hall facility. There has only been one person accountable for anything at juvenile.
I'm so sorry, ma'am. Your time unfortunately has expired. We'll provide additional information about the probation department and the CLERB in items 7A and 8D on tonight's agenda. Next, we will go to, I believe this may be Kathleen Lippett. Kathleen? Kathleen? If you can hear us, ma'am, you are muted. Okay, Kathleen, one more try. All right, ma'am, we'll try you again later. At this point, we do not have any additional requests to speak, Chair Delaney.
Thank you. Next agenda item is minutes approval. I think we had some communication problems with our emails. I did not receive the minutes. Did anyone else receive them? That was it? Okay. How about we have motion to continue until next month, our minutes?
Move to continue approval of the minutes until next month.
Okay, is there a second? All right, a second. Any other discussion? Could you take roll, Secretary, please?
For Eileen Delaney,
Yes.
Vice Chair Diane Fishler,
Yes.
Secretary Bonner. Dr. Arlie Brown. Yes. Andrew Hayes. Yes. Patty United. Yeah. Ariana Deputy Montalban.
Yes.
Yes. Yeah, I will.
Yes.
Thank you.
May I make a comment?
Yes.
If any board members do not receive materials, whether they be reports or agendas or attachments, if someone could let me know so that we can get these out to you in a timely fashion, so you have the opportunity to review them prior to the meeting. Moving forward, once Ms. Sanchez Dudley gets up to speed, all materials will be sent out no later than the 2 Fridays before the report, before the next board meeting. 2 Fridays, no later than 5 p.m. on that day. So hopefully this will resolve the issues of you folks not getting it. We discussed talking to IT about this issue. We didn't know it was this far in depth because we only heard from 2 board members that didn't receive materials. So we will again reach out and try to remedy the situation so that the new administrative secretary doesn't have the same issue using the same distribution list that has been used for 3 years. Thank you.
Thank you. Yes, go ahead.
If I could just make a comment. As you know, I reached out to you about the materials that I did not receive. And I just want to say this is the first time that I have not received the materials. So it does seem like there was just a technical glitch this week. I received the first 8 reports and we talked about it, Paul. And I just wanted to clarify that this was not trying to blame anyone. It's just, I do think that there was just a technical glitch this week.
If
Absolutely.
that was a motion, I'd second it. I
absolutely
always
understand.
get them. I just,
Yeah.
this time I didn't.
Yeah, I think that's pretty par for the course. We get it. We get them and we get them untimely.
Yes.
We'll look into it even more.
Okay.
We'll see what may have happened. The agenda and all public attachments are posted. Yes, Dr. Brown, but the reports obviously not. And
And that's one of the reasons I checked the website, realized, well, wait, they're on. I didn't get them. So, yeah.
what we could also do, just to make sure that just in case there are any glitches in reference to the publicly accessible materials, we can add each of you to the Gov delivery account that we send out to almost 900 people that have the agenda and the public attachments, and they seem to get them with no problem from that.
Yeah, I think
It's just the
that's,
reports that are going to be the issue. And so,
well, if we get those, then we know that we're missing the reports.
That's right.
yeah.
So,
that's true.
so
right.
we'll get them twice and that's good.
All
That
right.
way we'll know that.
We will take care of that
Okay.
component.
All right, thank you.
Well, thank you, Chair Delaney, and good evening, Chair, CLERB officers, and board members. For those of you that I have not met, my name is Ellen Gross, and I have been assisting with CLERB for almost 6 months. But I know that Dwayne Bennett has filled in for me a couple times. He's my former boss at the Port of San Diego in the Port Attorney's office. And I had some pre-commitments for time away, but I should be here most every meeting now. I was asked to do an overview of case deliberations, cooperation from the Sheriff's Department and probation departments in the context of Civil Service Commission hearings and issues related legal issues related to Civil Service Commission hearings and also the case deliberations that you all do in closed session. So I'm just going to, I only have 10 slides. And if you have any questions, it would probably be better if you waited until the end. And then we can do it that way. So the first important thing to know is that CLERB has a Civil Service Commission rule all for itself for its appeals of findings, your sustained findings that you all approve in closed session and that are later published to the website and served personally on affected deputies and or probation officers. This Civil Service Commission Rule 15 addresses the appeals from those sustained findings. The last Civil Service Commission hearing on a CLERB sustained finding was in 2017. Rule 15 itself was added to the Civil Service Commission rules in 2003. So it's been around for a long time, but it has not been used for roughly the last 6 years. Now, the appeal right is triggered after publication by the CLERB board to the public website and then service on the deputy who the sustained finding has been made against, or the probation officer. And under Rule 15, the affected deputy or probation officer then has 15 days to file a notice of appeal. So as a result, we have gotten 3 appeals, which I'll talk a little bit more about in a moment. But we did have a meeting with Todd Adams last week from the Civil Service Commission. He is their executive officer, so I could get a background and share it all with you, because I think many of you were not on the board the last time there was a civil service hearing regarding a sustained finding. But for reasons I can tell you farther down the road, we believe that there may be more. So this is part of the training to just kind of give you a refresher on some things and inform you as to these hearings. So the appeals are assigned to one of the 5 civil service commissioners randomly. So each of the 3 appeals that we've already received have been assigned to a different commissioner. The Civil Service Commission hearings are evidentiary, meaning that witnesses and documenting evidence are permitted, and it's kind of like a little mini trial. So they are also recorded for audio recordings to make a record of the hearing. The Civil Service Commission will provide the opportunity for either party to subpoena both persons and documents. So for CLERB, that will be important because CLERB is not the appointing authority for either the probation department or the or the sheriff's department. So our counsel that will be litigating these matters will be required to submit kind of a laundry list of deputies, complainants potentially, and other witnesses that CLERB will need to present its case to the Civil Service Commission. If we need documents, we can also get those. Mr. Adams did indicate there may be a higher showing of necessity to get those, but we won't know until we try. So our approach will be to try to get everything that we need so that we can be best prepared for the hearing and provide the best hearing that we can with the facts and the findings that you all have approved. The CLERB main witnesses will be the investigator and the complainant, if that is applicable under the circumstances and the type of case it is, and all others deemed necessary and relevant. And while documentary evidence that contains hearsay, i.e. it's not directly from the party that comes into the hearing to say it, but it may be a result of a report, while that may be admissible, when we can, it would probably be better to have the actual witnesses there. It's not always going to be possible. And in those situations, we'll try to get the hearsay in the best that we can. So these first 3 appeals, we'll be able to see kind of how it goes. And we will be able to report back to you on the hearings in closed session. To kind of get, a debrief, what went right, what went wrong, because I think this will be a learning process for everybody, given the amount of time that's passed since any civil service hearings have been conducted. And CLERB, importantly, has the burden of proof. And that means that CLERB goes first. CLERB has to prove the findings by a preponderance of the evidence, just as you all evaluate them in closed session. That also means that CLERB gets to do not only a closing statement, but then one more bite at the apple, kind of like the prosecutor in a trial. So that's kind of how the hearings work in a nutshell. The hearings will probably go from 1 day or 2 days, although the Civil Service Commission advises to overestimate in time because they would rather have everybody plan for longer and then have the hearing be done quicker. Because when the notice of appeal is filed, the CLERB administrative assistant will be reaching out to counsel for the probation department or the sheriff's department, our counsel, also the commissioner, because they have day jobs, and also the Civil Service Commission's own attorney. So they have their own attorney that also attends the hearings and plays a large role in advising the Civil Service Commissioner as the hearing progresses. So the deputy or probation officer who is the subject of the finding may be called by CLERB in its case in chief. So when we're putting on our case or our evidence, as well as in the defense case. So when the deputy's attorney wants to have them testify. So it could be two bites at the apple for the deputy or the probation officer, but that is the practice, and that is not uncommon for different types of civil service and or personnel advisory board hearings that I have been involved in the past. Now, the next bullet point is where the issue of cooperation comes in. Pursuant to the county administrative code that governs CLERB, all the rules that govern CLERB, specifically section 340.15, that code section that has been in effect since 1991 when CLERB was formed requires full and complete cooperation by all county departments and employees with CLERB. The issue that has come up is there's been a long history of how CLERB has been able to get deputy testimony or evidence from deputies during their investigations. And the common practice now, the practice that has been prevalent for many, many years, is that there is what's called a CERF. It is a written list of questions, as you all are familiar with when you read the reports, that the investigator submits to the deputies who are being investigated and asks them to complete. And those are handled and passed through with the PD, with the sheriff's department liaison or the probation officer's liaison. And then the investigator gets the completed CERFs back to use in the investigation. Now, what happens next is that an investigator may not have all of his or her questions answered by the CERF, or some of the responses made by the deputies or the probation officers are incomplete, or in many cases may ask more questions that the investigator wants to explore. So in that case, the CLERB can request that the deputy or probation officer submit to an interview. And the way my understanding is that those interviews are done is that the questions that the CLERB investigator wants to ask are provided to an internal affairs investigator. The CLERB investigator can sit in with the interview, but does not get to ask any questions on his or her own, just gets to listen to the IA sergeant or other person asking the questions, and then they can get additional information. However, as of 2003, and this is a practice that's been going on for quite a while, there's been a kind of a practice in the sheriff's department, and we're not as sure with the probation department because we have not had any discussions with them about this recently. But that deputies were not really encouraged to cooperate. And they found that, the DSA would tell their employees that, this probably isn't in your best interest. And there is a waiver form that the deputies could then fill out and say, hey, I understand that I've been asked to submit to an interview by a CLERB investigator. I'm going to waive that and I'm not going to participate. So then what happens is in situations where the CLERB investigator, and this is the important part, is kind of on the fence, or as we call it, the bubble of sustaining and not sustaining, the CLERB investigator may not be able to interview a deputy whose testimony could change the recommendation that would come before all of you when you do your consideration in closed session. So that's been a problem. And, whether or not that the current practice and policies that were done 20 years ago, when, from my understanding, DSA relations with CLERB were not as good as they are today, may have contributed to that type of an atmosphere. You will see, for example, today in one of our closed session, where a CLERB investigator was able to secure the testimony of a deputy, that it's referred to in the report as confidential information was received. And in this one particular case, it did help with the investigator making their recommended findings that you all will be reviewing tonight. So in that regard, also in 2023, Penal Code Section 13510.8 B8 came out as amendments to Section 13510. And what that is it is causes for decertification of a police officer, peace officer, sheriff's deputy, or other sworn officers' certification to be a police officer or peace officer based upon certain specified grounds in that code section. And one of them is a failure to cooperate with the investigation into police misconduct. And another penal code section, 13509, states that that does apply to civilian oversight bodies such as yourselves that conduct investigations into police misconduct. So this change in the law gives CLERB another ability to try to attempt to get more cooperation and more information from the sheriffs, deputies, and probation officers. So Paul has been reaching out to the DSA and their attorney, Rick Pinkard, who I know many years. And this morning we did have our first kind of meet and greet and meet and confer. So without going into what really transpired in that, because we are still meeting and conferring, and under the Myers-Milius-Brown Act, we want to keep that close to the vest so we can have the best, most candid discussions. I can say that I think that we had a very positive first meeting, and that we are going to be moving ahead and looking at some different options to enhance the cooperation and the ability to obtain more information from sheriff's deputies that will hopefully benefit our investigations with CLERB and you know, also the deputies to want to cooperate with CLERB. So that's all I'm going to say on that, just because we did just start meeting and conferring, and I don't want to say anything that could interfere with our meet and confer, because we all have the duty to meet and confer in good faith. So that will be an ongoing issue. And the reason that it's important for the Civil Service Commission hearings is that if we have deputies, and it may come up in a couple of the appealed cases where they did not agree to submit to an interview, but then they get up in their case in chief as part of their defense in the Civil Service Commission hearing and come up with a whole different statement of facts or different circumstances or other things that come up that the CLERB investigator and you all in reviewing the recommended findings had no knowledge of. It severely puts CLERB at a disadvantage. And it's also just uncomfortable for a deputy or probation officer, because what would happen is there'd end up being a lot of cross-examination on, okay, you never said this, you had an opportunity, and it would make it more adversarial than we would want it to be. So that's another reason why we're seeking to enhance the cooperative efforts between CLERB and the Sheriff's Department and also probation in this regard. So, you know, we will deal with it as we will again in these first three matters. So that will be interesting. And I will tell you too that I have been busy getting retained competent and very well qualified litigation counsel to represent CLERB in these hearings. As some of you may know, I have been a litigator for many years, but I am now in the Church of Reformed Litigators, and I am not doing any litigation, but I know how to oversee excellent litigators, and I'm very much looking forward to the attorneys that we will be working with. And they will be working with all of our investigators and Lynn directly. And I will be kept in the loop, and as will you all. So after the case has been presented and there's been a closing arguments, the Civil Service Commission's attorney will draft a tentative ruling for review. And by the commissioner that's the hearing officer, and then once that one hearing officer signs off on their tentative ruling, then it goes to the whole Civil Service Commission, all 5 members, for their deliberation and either approval or concurrence or modification or overturning it. So that means that with all of that to be done, we will not get opinions back on our Civil Service Commission hearings for about 1 to 2 months from the hearing. And then the remedy from that is the final decision made by the Civil Service Commission, and that serves as the final administrative action. However, either CLERB or an affected deputy or probation officer may file a writ of mandate, basically saying, Commission, you were wrong, in Superior Court. And those hearings are, so if CLERB findings were upheld and the deputy filed a writ of mandate, CLERB would defend that, the Civil Service Commission's findings in that regard. If the sheriff's department or the deputy was successful and CLERB decided to appeal that or file a writ of mandate, which we would discuss in closed session with you all under initiation of litigation, then the sheriff's department would defend the Civil Service Commission's findings in that regard. So to date, as I've mentioned briefly, we have 3 appeals filed involving 7 deputies. And it's my understanding that there are a total of 10 appealable findings at this time. So the CLERB case numbers that have been appealed are case number 22027, the Viesca matter, case number 22130, the Jones matter, and case 23-010, the Ackles matter. Yeah. Yes, the 3 notices of appeal that have been filed with the Civil Service Commission are case number 22-027, the Viesca, Viesca matter. Case number 22-130, the Jones matter. And case 23-010, the Ackles, Ackles matter. So that's really the end of my update on that. And we will be able to apprise you in closed session of how those are going and let you know what issues we come up with. And I am very hopeful and optimistic that not only will these hearings, which we are required to do, will make our process better, but will also give us a chance to see what, if anything, our investigations can be done better, getting better witness testimony, and if that requires further meet and confer on other items with the Deputy Sheriff's Association and the Probation Department. So now I'm going to move on to reminders when adopting and making findings. Your job as a CLERB board member, as you know, is to evaluate all the facts and circumstances of an incident before you as presented to you in a fair and impartial manner. So the biggest do's are reading the case file, especially, unless there's some technical glitch, but normally I know you all and I all get the full, the full reports to review prior to closed session. And also asking a lot of questions in closed session. And then please do not let concerns about what could happen to a deputy or a probation officer should you vote to sustain a finding, and let that influence your vote. And a lot of the things are, well, could they get fired? Could they lose their job, or could they not get promoted? And things like that. They're valid concerns, but when you're wearing your CLERB hat, it's really to determine whether or not the investigators' recommended findings fit with the policies and the facts as presented to you. It's kind of like being a juror, in that you have to be able to be fair and impartial in your review of these matters. Also, do not allow financial implications or potential civil liability to the county, to a deputy or probation officer, or what some people could consider, some type of money making for a complainant turned civil litigant or a plaintiff in a wrongful misconduct case against the county or deputies, influence your vote as whether to sustain a finding or not. Also because the CLERB sustained findings first and foremost are advisory, and they do not impact civil litigation, and they do not impact discipline of probation officers or deputies. Finally, do not let injuries to persons, protected classes, or affinity with a deputy or probation officer or person impacted by an incident bias you or impair your ability to remain fair and impartial. And I know it's very hard with these matters when we have people that are badly injured, people that suffer loss of their freedom, that get put in jail, and then you have cases where no charges are filed, and yet we have recommendations from our investigators who have done extensive investigations, and they found no policy violations. It is hard not to be moved by the trauma that you all see in these cases. But it's important that there's policies for a reason, and sometimes bad things happen and policies are not violated, or the conduct was justified. And that's important to remember when you all are considering these very important matters and very emotionally charged matters in closed session. Now, your voting options for findings, this is fairly easy. Voting yes means that you approve of the recommended findings made by the CLERB investigator. Voting no means that you do not approve of the recommended findings made by the CLERB investigator. And then I've had some questions offline about what it means to abstain from voting. Now, I haven't not been here for that many meetings, but I know abstentions come up in lots of different scenarios. So stating that you abstain from a vote means that you're making a conscious decision to not vote. And this is, you're still participating as a board member, but you hear the different discussions and questions, and you decide at the end of the day that you are going to abstain. And there are several reasons for abstaining. So for example, some include that you have a conflict of interest. Now, normally, if you feel that you have a conflict of interest, please speak with me before the matter is heard, because there are certain levels of conflicts of interest, and some are more important and more germane than others. If a conflict of interest is, oh, I know someone, a witness that's in the report, that may be waivable, and if you can still be fair and impartial. But there's other conflicts of interest like, oh, I, gave this person a job, or I have a financial interest with a complainant, or, I have another type of conflict like that. We should talk about it because there are different gradations of conflicts. And it's important to know that, whether you just walk out of the closed session, and we can talk about that before the matter comes. So when we get our reports, if you ever have that, please get in touch with me. I'd be happy to talk you through any issues or concerns that you may have, because it does impact the whole CLERB board's findings. That's why even something that may be personal to you as a board member does have a board impact. So when in doubt, feel free to speak to me about it. Another reason for abstaining is the fear of having a lone or a minority opinion, and that can happen. Now, I know from what I've learned about you all is, you mostly will all share your minds and your opinions about things, but it's also okay to be the sole holdout. But if that's something that leads you to abstain from voting, that is your prerogative as a board member. Another one is disagreeing with other board members. There may be a forceful disagreement that comes up, and it may just be to the point where the person just says, well, if they're not going to go my way, then I'm not going to vote at all. I'm going to abstain. And again, it is your prerogative, but keep in mind that abstention votes don't count as a yes or a no vote. So then you're kind of losing your voice in that regard. Another one is an internal conflict on an issue, and that may just be that you can't be fair because let's say that the recommendation is that there's everything was exonerated or not sustained, but you have a deep personal feeling that you cannot that makes you not be able to be fair or impartial. That would be another reason to abstain from voting. Then also there is the other one could be a lack of sufficient information, that you just don't have enough. And that sometimes that's important to voice during deliberations and discussion with your other board members. That may lead to continuing an item or bringing it back, maybe having certain other things done. But that's another reason for abstaining. So that is the voting options for the findings that you do in closed session. And now I just want to also do a brief refresher on Brown Act considerations. As you all know, all discussions, comments, deliberations, and decisions in closed session are confidential under the Brown Act with limited exceptions, such as the findings that the CLERB board approves. Your sustained findings are allowed to be disclosed publicly as they're published because they are personnel decisions. However, just because the sustained finding or the lack of a finding is publicly made and published, it doesn't mean that your discussions in getting there are free to be discussed outside of the closed session room when the matter is properly agendized before you. And that's really important. And only the entire board may waive closed session confidentiality. And where that would come up is if there was something where the board, as a board, wanted to make a statement of something that came out of closed session. And in that regard, it would be very important that the whole board agrees on exactly what that's going to be, how it's going to be said, and who is going to make that statement. And the full board needs to vote on that and approve it before anything can be disclosed outside of closed session. And also recall that closed sessions are also confidential because they involve attorney-client privilege communications and attorney work product. So it kind of has a double privilege going on. The information in closed session is privileged because it takes place in closed session and also because it involves attorney-client privilege and work product, as well as confidential personnel information under Penal Code Section 832.7, which is kind of the triple protection on top of that. So you have the trifecta of confidentiality when you all discuss these matters in closed session, or really any matter that you discuss in closed session, whether it be personnel evaluations, whether to litigate, anything that comes down the line of that, it needs to stay in closed session unless there's an explicit waiver by the whole board. And violations of the Brown Act can result in board actions being challenged by the public. There's a whole process where complaints can be received and a cure process has to be followed. Because what happens is where there's a Brown Act violation, it throws into question the whole action that you all took. And sometimes that means revoting on items, being given a chance to cure it, mostly through revoting. And then there's also in egregious cases, but it has been known to happen, disclosing confidential information out of closed session can be a misdemeanor. So it can be a crime. So it's really important that you keep closed session in closed session. And I'm happy to answer any questions about that, or if any of you individually ever have any questions about something going on in closed session, I can be a resource for you in that as well. And then finally, Robert's Rules of Order, just super quick on this because this could take a whole training in and of itself, and it will either put you to sleep or make you a parliamentarian extraordinaire. What I did though is I did provide as part of the presentation a cheat sheet. And the reason that I like it is because it tells you what you're doing, how you make the motion, whether you can interrupt a person currently speaking to make the motion, whether the motion needs a second, whether there's debate, whether the motion that is made can be amended and how many votes are needed. But in general, Robert's Rules of Order are considered the industry standard across the world for parliamentary proceeding and the conduct of board meetings, both public and private. And the main one is that everyone has the right to participate in discussion if they wish before anyone may speak a second time. So I know Chair Delaney, I've seen her in action. And the whole idea is you kind of go around and get everyone to say their piece only if they wish to, before there's further interactions from other board members that have already spoken. And everyone has the right to know what is going on at all times. And only urgent matters such as set forth in the cheat sheet are where a speaker may be interrupted. So it's really important to let your colleagues finish what they're going to say. You can go back and forth all night long if you want to, but everyone needs to be able to have their say. And Robert's Rules is designed to help with that. And then finally, only one thing, a motion, can be discussed at a time. So it must be thoroughly discussed, debated, and either voted on before something else can come up, with the exception, of course, of amendments, and that is covered in the cheat sheets too. So that's a very brief overview or refresher on Robert's Rules of Order. There are lots of good YouTube videos. If you are having insomnia, you can Google Robert's Rules of Orders, and there's some very informative and educational free videos that you can watch. So I'm happy to take any questions or discussion. I'm not asking for any board direction or action. This is just a presentation and was agendized as such. But again, if you have any questions, please let me know. And I thank you for your time and your consideration.
Thank you. Does anyone have any questions? That was excellent.
Very good. Very helpful. Thank you.
I want to make one point, is that we have excellent, well-trained, so competent investigators. And, I appreciate the work that you all do. And that's why it's so important that if we are feeling emotions about something, we have to go back to what are the facts. Because if we sustain a finding, it can go to the Civil Service Board. And if we don't, that's our option too. But thank you very much for all your hard work. Yes. No, this is just us.
As our attorney. Okay, as our attorney, thank you. Is there any liability as a CLERB member that we need to be concerned about?
Board member Brown, are you talking about
Personal
individually? Okay,
Individually,
no.
yes.
Okay, it's I can't give you every different scenario, but when you make a decision as a board member, you have legislative immunity. You also have legislative immunity for what you do and say from the dais. So this is the best place to say, whether in open or closed session, what you think about things, as long as you follow Robert's Rules of Order. And generally, it's a very high standard to have any personal liability imputed to you for your decisions as a board member.
Okay. The other question is, when are we this may be kind of vague to you, but how cross-culturally competent are the attorneys or the firms that you're selecting we'll talk about that. We'll talk about on a different time.
I'm happy to discuss that with you. I will say though, and I think it's appropriate to say it in public, is when CLERB retains counsel, just as they retained me, CLERB cannot have counsel. They cannot use counsel that the county council uses
Okay.
or a council that does business in any way, shape, or form with the county. I did have a candidate that I have worked with in the past who I thought would be excellent to do the hearings. However, she and her firm were in discussions to be retained for a civil litigation matter that I thought was remote. But the county council has their own policy on what they believe is a conflict. And a lot of conflicts, you have to have the Board of Supervisors waive. And for the one person that I was looking at, the county council indicated that they would not recommend that the board waive that conflict. So it does impact the attorneys that we can get to do these types of hearings.
Well, I have a question. What about dispute resolution? Is that at all used in any of this? When we go back and forth, alternate dispute resolution, like mediation or whatever. Some say that minimizes the cost, time, and everything else. But I guess we shouldn't be concerned about that.
So are you speaking about doing a mediation with a deputy or a probation officer? There is no mechanism for that in place at this time. And I don't know if that's something that the board would want to look into. And I don't know what the appetite of the sheriff's department would be in the Deputy Sheriff's Association. I do know from my experience doing police legal advisor work that a lot of agencies do have specifically certain types of, alleged misconduct or violations of rules that they would have where the complainant would meet with the deputy or the probation officer and then try to mediate it that way. But right now, that is not an option that CLERB has on the table.
Thank you.
Okay, Marianne, and then we'll go to you. Okay.
Madam Chair, I have one comment and two questions. Do I take them all at once or, okay. First comment is just to clarify in terms of liability. Would it be the case that CLERB members would be liable, however, if they breached closed session protocol and spoke about closed session deliberations outside of closed session? Could they be personally liable for that?
Yes, they could. But again, the misdemeanor, there could be potential criminal liability. But what would happen more is that the decision of the board that was made in a closed session where the Brown Act was violated or information was disclosed would have to be remedied. And the attorneys, when attorneys get involved in doing this, may make a claim for attorney's fees. And it also just is kind of bad optics for any board to have to go through and deal with that. And leaking is not, looked upon by the public very well either. Because closed session is really, they're the only exceptions for all the other public business being conducted in public. So it has to be taken seriously. But yes, there is potential criminal liability for disclosure of closed session information.
Thank you. I think I have the floor. My next question is, you said that when the investigators provide the questions for the SURF questions for the deputies or the probation officers, they provide the list of questions to an IA, and then is that what you said? Yeah. And then the IA asks the questions. Is that correct? Did I understand that correctly?
I may have misspoken. I will defer to Paul.
Okay.
Very similar. It's actually the Division of Inspectional Services, our liaison division. They're the ones that we send the questions to and through.
Mm-hmm.
And if we were to have an interview, if a deputy would agree to an interview at this time, those questions, we should not be providing the questions for the interview prior to us going there and meeting with the Division of Inspectional Service liaison, who will then ask the questions. They will notify the deputy of the Liebarger protections that they have to participate in this administrative investigation. They would ask our questions for us, but we also have had the opportunity to the sheriff's department has been gracious enough to allow us to ask follow-up questions if something has come up.
That was my question. I wanted to know if our investigators had an opportunity to ask follow-up questions, because that seems like that would be really important. And they would lose that opportunity if they weren't conducting the interviews themselves. And then my last question, and I've seen this in several of the reports that, the deputy or the probation officer provided information to the investigator, confidential information to the investigator that led them to their conclusion, which to me has always been quite confusing when we read these reports. And I would really like to know, what is that information?
Yeah.
Why are we not privy to that information?
You are privy to the information, Vice Chair Pintar. It's in the report. The only time you should be seeing that Deputy so-and-so provided confidential information that was used on the course is in the public rationale, is in the hearing notices and on the agenda.
Okay.
So,
So
but in the
when we get
report,
the full
inf-
report,
you have
we
all.
have it.
You
Okay,
have
that's what I wanted to
everything
know.
that we have, everything.
Perfect. Thank you
And-
very much.
Yes, yes.
Thank you.
Ms. Kink?
Thank you. I'm wondering if you could speak a little bit on the Brown Act as it is concerned with board members being in social situations, like at a cocktail party when there's a full quorum. You can actually have that without, as long as you don't discuss board business, right?
There's two different ways. There is a ceremonial exception in the Brown Act where you're going for purposes of ceremony only, and there is no there's no business on the agenda. But it's always wise to not huddle together, especially a quorum of you or more. Just
Okay. Okay.
Thank you.
Good.
And Secretary Kink, I can provide more on the actual contours of that if you'd like.
Thank you.
Okay.
That'd be great. Okay. Ms. Keen, are you?
So I have a question and I'll try to phrase it as best as possible. I apologize, I'm quite tired. I think one of the biggest things about CLERB when we go into closed session is that we are looking at the report, but we're actually looking at the way the policy is addressed. So our interpretation of how that policy should have been ensured or how it should have been enacted on the sheriff's department may be different than what the department itself thinks that they should enact. This causes a conflict, a moral conflict in my opinion, which then translates to this is not something that we can go and argue in front because they didn't violate policy. Well, the violation of policy depends on how you're looking at that policy. It depends on how you're interpreting that policy. And for me, my problem has continuously been, is it not a moral obligation for us to look at that policy as it should be thought of in terms of housing individual humans? I agree that everyone sees the applications of different policies differently. But that's why you have the investigator that is looking at the policies with the facts that are presented. I also understand that you do make recommendations as to policy changes, additions, and modifications. So you do have a vehicle for that. But but taking it to the extent of where you have a facts that the investigator has found in their investigation and applying those to the policies that are already in place, that's what you're doing when you're evaluating whether there was a violation of policy.
Okay. I know that Dr. Brown has another comment. Does anyone have anything else they want to ask before I go back to Dr. Brown? Oh.
Many years ago.
Hang on a second. Let me just
Okay.
make sure that they,
I know they have questions out there before.
yeah, but this is just the board.
Okay.
Mr. Hayes, do you have anything that you want to?
I would ask just for clarity, because I think it's important, is when we make a determination on a finding and that's public, vote in closed session. And I'm on a school board, and so I vote, we all vote in closed session. And sometimes those votes are published depending on whether it's by unanimous or by roll call or whatever. So I think it'd be important for members of the public to know when that happens and when it doesn't, in our case. Does that make sense?
I'm not
So
sure.
for example, like when we're dealing with an HR matter, right, we'll say, oh, hey, look, this is what happened. The board unanimously or by roll call, and the member who said no or yes or whatever, we publicly announce those names of those folks. Does that make sense?
You mean your members?
Yes.
Who voted for?
Let's say we have a finding and we all vote to sustain it. When it goes out, does it say unanimously sustained? Or does it say, let's say we say 2 of us vote no, does it say 7-2? Does it say 3-4?
I don't believe so.
May I? Sure.
Mhm.
The only thing that in my 2 times here at CLERB, and Lynn can correct me if I'm wrong, we document, we keep notes of that. The secretary will keep notes. We will keep notes of the vote in closed session. We don't report out the vote on the findings. The only thing I've ever seen this board report out the vote on is if they hire someone, fire someone, and their evaluation, whatever, right? That's the only thing that I have seen. When we were back in open session, everyone knew, but right now we have them documented. We do not put those out, and I don't know if that was a county council decision that we don't put those out. We just never have done so.
No, we don't either. That's what I was kind of getting to. Is it was brought up early on in my when I was first elected, and board members were afraid to vote or didn't want to vote a certain way because of all the reasons you mentioned. And so I wanted to just highlight that. I learned that early on.
Mr. Ware or Mr. Mondragon, do you have any? Yeah.
First of all, thank you for the information. Very educational. I really appreciate it. And Ms. Roberts' rules is excellent. Thank you. You brought up in your presentation about abstaining, and you gave a lot of great examples. One that you didn't mention, I just want to clarify that if we were absent, could we abstain? Yes, you can. And that often happens when you missed a meeting and then the minutes, you vote on the minutes and you can abstain because you don't have sufficient information. Okay, thank you.
Did you? Yeah.
Thank you for the information. It was really good. So if we can get a copy, that would be great. Wondering for the Brown Act, when information like discussion, is that protected within like closed session? Like any comments of discussion?
Yes, it is. That's the
And
whole
Okay.
purpose, because the Brown Act would be not what it is if you cannot have robust and candid discussion between you all as a board. That, and there's so few exceptions in the Brown Act that that's why they're so closely held.
And for what does the process look like if any outside, like any closed session comments were made outside of closed session after that meeting?
So just hypothetically, someone divulges something from closed session of a board member, hypothetically, and someone overhears it. Well, a lot of things could happen. One, there would be a report made and the board may decide to do an investigation of that to see if it happened. And, to take some type of action against the board member, maybe a censure or an admonishment. But also there's, criminal liability can happen. I have not seen any criminal liability for leaks before or disclosures. I think, again, it's going to be fairly egregious, but I'm not the DA. And I think also it depends on the damage to the board. and what the type of action was. Now, I certainly think that if any board member here disclosed any confidential information about one of the cases or any statements that were made by sheriff's deputies or probation officers, that would be very, very bad. And I also think that that there's more risk when you, you know, in terms of any of your personnel decisions with your own personnel, those really need to be sacrosanct. Because there's other Brown Act issues that come up that can make something that was a personnel evaluation of complaints and charges, and that has due process implications for your employees. So that's why it's so important. And again, if you feel the urge that you need to say something, one, you can always talk to your whole board about it in closed session and say, well, I'd want to say something outside of closed session, and see if the board would vote to do that. But normally in these, the discussions and the deliberations, I think discretion is the better part of valor. And you can't go wrong with not saying anything.
And then, so those, like if there were to be a situation, then that gets shared with you or to Paul, or what does that process look like?
Well, I don't know that CLERB has a process. I would have to look at your rules and regulations. And that may be something that would require that you all come up with a policy for your own governance on that issue. That's what I would recommend, just because you all know, what you do, and you're separate from other boards and other county departments. And if that is something that you're concerned about, and given the extent of confidential information that you all review every month in closed session, it's substantial. So there may be a need to craft some type of a policy and maybe some type of a reporting and complaint procedure for that, if you all would, that's something you would all want to do. I mean, anyone could also go and refer it to the DA or the city attorney, say, hey, I heard, member X say this. And so there is that too. Now, whether or not they would file charges or do an investigation, whether it would rise to the level of a public corruption type of thing that the DA's office or the city attorney's office would look at, is entirely up to them. And I am not a criminal practitioner. But if there was some type of administrative process that you all would like to look into, or a policy, we can always discuss that further.
Thank you, counsel.
Mr. Parker.
Thank you, Chair Delaney. In reference to that question, I would strongly encourage not to come to me for any violations, because all of you are my boss. So I would prefer that would go to the chair. And I think if this board gives me the permission, I think that's a wonderful idea to draft something for your folks to review for any said violations.
Let's go ahead and do that. Before I go back to Dr. Brown, is there anyone else have anything?
Chair Delaney, if you are going to do board direction, there probably should be a motion.
You're right.
And a discussion.
You're right.
Going to make?
Would you like to?
I'd be happy to. I would move that we ask Mr. Parker to please draft a potential policy for managing violations of the Brown Act, including reporting out of closed session without.
Okay.
Who seconded?
Nadia.
Nadia.
All right. Any other discussion regarding the motion? You ready?
No, hold, sorry.
We're gonna go back. It's okay.
Okay.
Hang on one second, Lonnie. Dr. Brown, did you have a question regarding the motion?
No.
Okay. Okay.
Okay. You ready?
Yes.
Chair Eileen Delaney?
Yes.
Vice Chair Miriam Pintar?
Yes.
Bonnie Kink, yes. Dr. Arlie Brown?
Yes.
Andrew Hayes?
Yes.
No, Nadia, okay.
She seconded it, so I think she's probably.
Well, not
but we have to-
necessarily.
We'll have to wait for her. to come back.
Ariana Federico Mondragon,
Yes.
Tim Ware,
Yes.
G.I. Wilson.
Yeah.
Okay, well, it passed, so.
Okay. Okay. Thank you. May I, Dr. Brown ask his final question?
Oh, of course.
Yeah.
Yeah, you know, I often interchange the terms cross-culturally competent with the transformational justice. So bear with me. I was sort of like piggybacking off Ms. Kenayu's question. She talked about being the moral thing, or let me give you an example of something. Years ago, I was a hearing officer for the Housing Authority, and we had policy and rules that they were right there for us. We had this one example where there was this grandmother who had taken in like 4 of her daughter's kids. And the kids and her daughter was like nowhere to be found. But the policy was that you couldn't have anyone there. Now, I saw this whole thing differently than my compatriots. And some people say, well, she got to go, she violated the policy, but where is she going to go? So do you have, I think that's what she was talking about, the moral obligation to look at things from a different standpoint. Is there any, when you say that we can't have any consideration for, somebody going through it, has to vote up or down on the rules with the policy, is that what you were actually saying? There's either or, there's no and?
There can be an and, but it is, at the end of the day, you all have been given facts that have been found by professional investigators. You've been provided the applicable policies. And if you believe that a policy is inherently wrong or immoral, then, you would vote to say that they well, in this case, it's sheriff's deputies and probation officers. But if you believe that, I guess what it comes down to is kind of like a jury nullification thing, right? Where you are going to vote your conscience. And that is okay. But the problem is going to be, and I'm not dissuading you from doing that because you all have your own individual mandates that you are, here. And as long as you're fair and impartial, and you don't have conflicts of interest in voting, you can vote or abstain however you like. But at the end of the day, if there's sustained findings and they get appealed, and we can't get them affirmed by the Civil Service Commission, or even then go to a writ of mandate and say that, this policy was wrong, this is a bad policy and we're not going to follow it, it's highly likely that CLERB will not be successful. And so in a way, I think it comes back to making policy recommendations more proactively and more assertively as part of your business that you do here. But trying to translate that through your voting for sustained or not sustained findings may not be the most effective avenue to achieve that.
Okay. Thank you again. Really appreciate it. It was very, learned a lot. Thank you. All right, well, next go to the executive officers report. Mr. Parker?
Thank you, Chair Delaney. I'd like to first start off by, I think last month I mentioned that we were about to hire an administrative secretary 3. Well, we did. And she's 2 people to my right, Amalia Sanchez Dudley. She was hired on November 3rd. Hopefully folks got the email.
Yes, we did.
All right, perfect. So basically, Amalia comes to us with 2 years of experience at the county, mostly with the Health and Human Services Agency. She's a quick riser. She started, she was an administrative secretary 1 and administrative secretary 2, both at what used to be Child Welfare Services, which is now Child Family Wellbeing. She has her bachelor's degree in business management and is looking to start her master's degree within the next year. I can't tell you how excited we are that she is here. Thanks. In reference to the special investigator vacancy, we received 93 applicants. We'll be doing the first round of interviews within the next 2 weeks or so. That's the goal. We received actually very good candidates when we looked at them and screened them. We're excited to see where that leads us. I'll give you an update next month or 2 weeks from now, to tell you the progress on that. On November 1st, CLERB was selected as one of the finance and general government group departments to provide detailed information about our operations at the quarterly meeting with the county executives. So I did provide a comprehensive overview, and Ms. Akak was with me and under 4 basic categories. Number 1, increasing transparency. Number 2, reducing in custody deaths. Number 3, your policy and procedure recommendations. And number 4, recruitment of board members. I highlighted all of the proposed rules and regulation revisions that this board has approved me to move forward with, and some of the ones that were tabled and that I was asked to come back with additional information on. I believe the presentation was well received. It was very informative and well received. So that occurred on November 1st. On November 7th, Ms. Gross, Ms. Setzer, and I provided a POBAR, a Peace Officer Procedural Bill of Rights training to all the San Diego County Office of Ethics and Compliance personnel. On November 9th, Special Investigator Aldridge and I took we went to Central Jail because for a general tour of the booking process. And I got to tell you, I've been here for several years, and that was the most informative tour I've had. And I want to give a special thanks to, obviously, Assistant Sheriff Adams Hydar for making it happen. That's number 1. But number 2, to the people who made it, who were actually there with us. And that was Commander Kenneth Jones, Captain Kyle Bible, Lieutenant Cesar Ceballos, Sergeant Michael Tingley, and Sergeant Jessica Applebaum of the Contraband Narcotics Interdiction Team. We got to see a little bit about what they do. And learn a little bit more about their body scanners in the booking area. I strongly recommend, any CLERB member who's not been there, any CLERB staff member who's not been there, at least recently, within the last year, there have been some major substantial changes. And I highly recommend that if you folks are interested, let's make it happen. Okay.
I think most of us, it's been a while. So I think we'd have a lot of interest in doing that.
And I'll ask Ms. Gross, so for something like that, no quorum. So we'd have to break it up into 2.
That would probably be
Best. Okay.
preferred.
Okay. Thank you very much. So I will work with our Division of Special Services liaisons and try to put some dates together, and let's make it happen for staff as well, Ms. Setzer. So thank you. And obviously there were a bunch of other folks with the Sheriff's Department who helped us at that time. I don't know their names, but they assisted as we went through. So that's where we stand with that. So on November 13th, Chair Delaney, Vice Chair Pintar, and myself met with county executives to discuss our upcoming open session agenda items in the interest of transparency, and simply the interest of transparency, so that everyone knows what we're talking about, what CLERB is doing. We'll talk a little bit more about NACOL, but 6 of us went to NACOL, and that would be CLERB members Federico Mondragon, Ms. Keen Ayub, Secretary Kank, Doris Akak, Special Investigator Spencer Clue, and myself. We went to the 29th Annual NACOL Conference, and we'll talk about that under 7A. On November 21st, Ms. Gross already talked about this. Very informative meeting that myself, Ms. Akak, and Ms. Setzer had with Civil Service Commission Executive Officer Todd Adams. Extremely informative, very timely, of course. And then earlier today, Ms. Gross also mentioned the very productive meeting that we have with the DSA representatives, DSA counsel, Lieutenant Perkins, and Sergeant Bracey. As reference to the investigative workload, which is attachment B, I think, and that's for October. We're almost in December. November, we're almost at our annual total from last year. We're well on a pace to almost get to be 180 cases. That's a little different than last year. Last year, we had 165 cases, but a lot of those, not a lot, but substantial number of those were the same complaint over and over and over again. That's not the case this year. These are there's some repeat complainants, but I think we're getting the word out about who we are and what we do and the movement we're trying to make and to increase the transparency of the investigations. So I think that's helpful. Attachment C, basically we put that in order for you folks to see due date, when they're due, as far as POBAR concerns. There is one report due, and I know that Ms. Schmidt and I have had conversations, and so that will be on December 12th, but there are reasons for that. I don't want to bring something forward to this board without an impacted member or family member having had an opportunity to sit down with me, talk to me before we bring it to you folks. So what you're going to do, and we haven't had that opportunity just yet, but we will before December 12th. And then finally, attachment D. These are some of the articles that we sent out, and quite frankly, with as busy as we have been, I haven't sent out as many, but I do want to address something that was brought to my attention, and I owe this board an apology. The most recent article that was put out might have tended, my understanding is maybe some board members were a little concerned that it seemed to paint the EO as over here and the board over here. I don't see that, but if anybody on the board saw that, my deepest apologies to you for that. I do believe that we're all on the same page. I do believe that. And I do believe that the CLERB members, they care, and you care, and you want to provide the best possible oversight services. I know that. You guys are volunteers, and here you are, late into the evening. I understand that, and I will always say that. So anybody who thinks different, my humblest apologies. I'd like to think we're on the same path, which is to independently, in my opinion, you guys correct me if I'm wrong, independently to investigate the complaints of misconduct and the specified incidents, identify any systemic issues and trends pertaining to both the sheriff and or probation department policies and procedures, prevent the deaths of those people in custody or under county supervision, make recommendations to assist the departments in providing their best possible services. I think that's why we're here. And I think we probably can all agree on that. So thank you for hearing me out on that. In reference to the policy recommendations pending response to Sheriff's Department, we were going to have a few of those for this month's meeting, but they will be for December 12th. There's still 7 technical responses that are out there. Probation has 0. And that's where we stand for the executive officer report. And I ask for any questions.
Thank you. Let's see here. I think I'm board chair report. So just to expand on what Mr. Parker said, we are having monthly meetings with county executives team for the purpose of transparency. I think it's working out really well. It's a good thing for everyone to be on the same page and know what's going on. There was something else. Oh, council, I would like to see a couple of things on the agenda for next month. Do I need a motion or can I just ask for them to be on the agenda? Since
Yes, Chair Delaney, you don't need to do a
Okay.
motion. It's your discretion
Okay.
what to add.
All right, I would like to see us discuss the statute of limitations. I think that's something that we need to talk about. Also, maybe more information about resources on the jail drug screening. I think that's something we maybe the sheriff's department there. We could talk with you about. And the CIRB reports. I think that's also something that we need to discuss. And that ends my report. Oh, yes.
The monthly meetings that you have with admin, what type of admin are they?
This the county executive team. So that would be Ebony. She is in charge of I'm just blank on it. What is it called, Paul?
She is the Deputy Chief Administrative
Yeah,
Officer for the
thank
Finance
you.
and General Government Group.
So she's just and some others, personnel people, just so that they know what's going on with CLERB.
So it's not to like sheriff's department setting our agenda, is it?
No, not at all. They don't
Okay.
set our agenda. We set our agenda.
Okay. I just want to make sure that if full transparency means that we know what's going on too.
Understood. Oh, and speaking of agenda, just for so that we get a real grip on what the board is all about and the board wants, Paul is giving us drafts of the agenda and Marianne and the officers here are reviewing it, adding, deleting, and just so that we can move forward and continue our mission. Sure.
And in that same vein, I think that everyone on the board has an opportunity to say what you would like to see on the agenda. You can do it here.
Or
You can do it
contact
by contacting
Sure.
Eileen, any of the officers. I think I've often sent a note to Paul and said, I'd really like to hear about this. And it's on the agenda. So I don't want that to be the fact that the executive officers are talking about this pre-agenda meeting to in any way discourage anyone from having anything
Absolutely.
that they want to have on the agenda. You should feel like you should tell us that you
Yes.
want it on the agenda.
Mr. Parker? Oh, Ms. Bondragon?
So if agenda items are deleted, have you deleted any agenda items? Do you have a discussion? Can we know about what items have been deleted?
I think what we've done is we've revised a couple of them and said, hold off on those. Our goal, if I may speak for us, is we want to get going. We want to get the things done that are in process right now. And that's our main focus.
Can we know about any agenda items that have been postponed or deleted? Or are those usually in your chair reports?
I can report
about-
them
yeah.
if you want. Sure.
Yeah, I think so.
Yeah, absolutely. Mr. Parker?
Prior to that comment, all I was going to say is that technically the rules and regulations make very clear that the chair is responsible for the items on the agenda. That requests for items to be placed on the agenda can be made through the executive officer, but ultimately it's Chair Delaney who is responsible for that. I will admit, I guess I should admit publicly, that in the past, I have put things on the agenda and tried, to talk about things and probably caught the chair and the vice chair and the secretary off guard when we did have our meeting to talk about what we were going to talk about on the on the day of the meeting. So we have turned all that over to the chair to be consistent with our rules and regulations. And so that is what we will do from this point forward.
And I have in turn asked the vice chair and the secretary to help me and advise me on what we think is appropriate.
Okay.
Mary Ann, and then, yeah.
I was just, some of it just has to do also with, which we're going to talk about later on the agenda tonight, timing. How much time are we committing to so many items? I have felt in the past that the agenda, the open session agenda has been so loaded or overloaded that we end up ending open session at 9 or 10 at night. And then we go into closed session where we have 16, 20 cases sometimes that I feel we aren't doing justice to them by deliberating so late after a long meeting, when I want to have a really robust conversation about those. And we don't, it's late and we've all been here a really long time. And I feel like it does a disservice to the families and the complainants and the deputies who deserve our full attention, not at 11 o'clock at night. I hope that makes sense.
Absolutely. Bonnie, did you need to say anything? Mr. Brown, Dr. Brown?
I do. I would like to say something that we should add something to our agenda about making sure that something about how we interact with the public to include them and have them be more inclusive. I don't know how we do that. I'm just get some kind of, I'm just saying that I think it would be, it's a trust building, transformation, just cross-cultural thing. Just see what from them, how they feel about what we're doing and vice versa.
And I think we're going to be discussing that further down the agenda.
Okay.
Good job. All right. Now we're going to go to news business and I'll turn it back over to Mr. Parker.
Thank you, Chair Delaney. And I think as I mentioned to you earlier, I named the 6 folks who went to the NACOL 2023 annual conference. It's the 29th conference and it was in Chicago. I completely forgot. I literally forgot where we were. We were in Chicago.
Hawaii.
And it was attended by the most people that had ever attended NACOL conference, almost 700 attendees nationwide. Many of them were from brand new agencies, brand new civilian oversight agencies. So I'm going to leave it at that. I'll talk a little bit more about my takeaways from it. Not wanting to put anybody else on the spot, but if there's anybody who attended the conference who wants to speak before I do about the takeaways that they got from the conference, with Chair Delaney's permission, the floor would be yours.
Absolutely.
And then I'll wrap it up.
Sure.
So it's my first year on CLERB. It's actually my first year on any board. So it was a really good opportunity to go to the conference. I learned a lot. I think it's always really great to hear what other cities and counties are doing, because we don't always need to reinvent the wheel. and I think that at some point there was conflict or they had to find a consensus to how they're holding each other accountable and how they're really bringing values of transparency. So I think that that Chicago, just as a city, I didn't really know much of Chicago, but I think that I was just really impressed by a lot of the departments and agencies that exist and that they have for folks to have a process of police accountability. I also learned a lot about in custody, just how far behind I think a lot of people are, like in how we treat people in custody. Like they are people. We heard a lot of testimonies about people who were previously incarcerated, and everything really does impact them. So that includes food, what they have, if they have clothing, if they have menstrual pads. So I think really that was really important for me to just kind of like learn more of, because all those needs are just basic needs that people need to have anywhere and everywhere, regardless of where you live, where you come from. I think overall, like I really learned that a lot of the community members and impacted families are the reason why like systems are changing, and why they will continue to change. So I do appreciate, the folks that come online, that come in person to give public comment, because I think that it helps us facilitate more the policies and the discussion here in this space. And it's really valuable when we are having those conversations, especially in closed session. Yeah, it was a really great time. It was a long time. We were there for a while. But just thank you for the opportunity to clear.
I'm glad you were able to go. Were you able to talk with other people from other areas?
I did talk to one person from the Chicago, the COPA, I think that's what they're called. So that was really cool of how they do like they bring in like a communications aspect for folks to understand like what does a complaint process look like. They try to really like tap into different areas so that they can reach as many people and help as many people, and be held accountable too by the community. So that was really cool. I also saw a lot of members from the News Commission from San Diego. So I was able to meet them. They do have like a new commission that I actually advocated for in the past year. So it's interesting to see how everyone's in different places. Definitely more proud of like where CLERB is than in some places, because some folks don't even have an opportunity to look at investigation reports or have investigators. So it really makes me appreciate like the work that's being done here and is continued to be done.
Thank you. Bonnie, you?
I think Ariana said it well and said all that I would want to say, except we have fun.
I want to say thanks to the board for the opportunity to go. It was very informative. And I mean, ultimately,
Is your mic on?
it is. Hello, can you hear me now? Is that better?
Yeah.
Okay. Ultimately, if we want our work to be valuable, it has to be good. And I think that's what we're trying to do here. And I think we constantly need to strive to improve. So, like Ms. Kank said, or Ariana, you might have mentioned, it's in some states, it's not so great. So not that it's great here. I think there's a lot of room to improve, particularly around how we interact with the community and how we reach out to the community. I'm glad to see that's on the agenda tonight. So just thanks for the opportunity.
Great. Did you want to say something? Mr. Parker? Oh. Nadia, I know you want to say something.
I'm offended. Like I always talk.
I think Ariana said it well. I think she did it. I do want to note, though, that the element of transparency works both ways. Having transparency and having those levels of oversight the way that they had, especially in Chicago, where I think they have 5 different branches that look over and they do individualistic look. When you look at the police departments reflect the communities. And that's important because if the communities are joining these police departments, that means they trust the system enough to be part of it. And that comes from full transparency, full community oversight, full community investment. I think oftentimes we forget that looking at it from a police officer's point of view, we may not be trained, so we may not know everything, but they're also looking at it from a site where they've been involved in this situation for so long that they may forget what it's like to be a community member and see how it is to interact with the police, how that can be a detriment to your life, how it can ruin your life, essentially, even with just a ticket that translates to a towing of the vehicle, that translates to not being able to get to work. So all of those points were brought up there. And I just was so grateful to be in that room and have these people speak to what their own incidents and experiences were and to have that bravery to come forward.
Well, yeah, I guess there's some things, that you don't think about until somebody brings them up, and then you just go, oh, I didn't think about that. So thank you for attending, all of you. Paul, did you want to say something? Mr. Parker, did you? Oh, Norris.
Okay, so I'm not really a great person talking in public, so I'll try my best to share what I learned. It was a really great opportunity for me to attend. First time, Nicole, and of course, sharing good times with the board members and to learn more about them, actually. That's a great opportunity. And of course, the learning experience is wonderful. So many things, learned, and we were exposed to learn about other civilian oversight nationwide, like Ariana just mentioned. But the most thing that I believe really helped me is learning about how to form a policy recommendation and the phases that we have to go through is to be, to make sure that the policy recommendation covers and address the issue, not to cover it, and to be very clear with the language when we write the policy recommendation, leave zero ambiguity or like multiple maybe interpretation for someone who reads it, which is very important. Moreover, is not only writing or putting the policy recommendation, is to evaluate the impact that that policy recommendation made. So that the data science come into the scene, and how important that we have to be very very comprehensive when we collect the data. It's not like one way, it's always, all directions, all possible directions, and be careful with even not to ignore the unseen layers when it comes to the direction, because the unseen layers may really give the accurate readings, and the general data will most of the time will give false reading. And the evaluation process is not a one-time thing, it's an ongoing thing, because things are evolving and new parameters may come to the scene. So it is very important, because the new parameters may be like a red flag for us to take care of, or to think of, maybe something that when we look at these parameters, maybe will help us to prevent anything that we don't see in the future, any incident that we don't see in the future. Of course, that all comes with the full collaboration with the department, that of using the policy, and full transparency, because they are the main source of this information. We will know nothing if we don't see the numbers from them, and I'm so proud that we are now working on the data death report, and I believe that's going to highlight the good work that the sheriff department is doing, and of course we will see that through the numbers that they will share with us. And eventually the whole report will be shared with the public and of course the board. And thank you.
That's wonderful.
Thank you very much, Norris and everyone. I wanted to say like, they pretty much said it all. I just have a couple things to add to it. Going to these, this is I think my fourth one, and going to these conferences, despite the fact that there may be disagreement, you know, like I might disagree with a member of the board or the chair or whatever, right? Very fortunate. We are very fortunate. We have been around for 30 years and we've gone through the hard stuff. There's more hard stuff coming. But I leave these conferences very appreciative that I'm working here and I'm working with this board in this county under the Finance and General Government Group. Because we do have, now we're not, you know, we'll talk about a little bit about the financial support. We have a heck of a lot more than we ever had. The trend, and I mentioned this last year, the trend for civilian oversight agencies is 1% of the budget of the overseeing agencies, 1%. So if you look at the Sheriff's Department budget and you add it to the Probation Department budget, we actually have 0.14% of their budget, 1/7 of what NACOL and the other civilian oversight entities are trying to have. Chicago has it. But anyway, so that I took away from that. One of the things I also took away was, you know, a lot of these other agencies, they do all like a lot of police stuff. But no one talks about probation. There's only one other probation oversight entity that we're aware of in the country, and it's our neighbor to the north, kind of a neighbor, LA. We did meet with them and talked about, you know, how we have similar issues, whether it be with court orders to get records or deaths of probationers or juvenile detention facility problems or whatever the case might be. So that's exciting. That's exciting. I did sit on two panels. One was journalists and authors as catalysts for change. As we all know, I think it's fair to say that journalists are the original civilian oversight of law enforcement since its inception. And then also over the last year, spent about 100 hours working on a group to deal with set performance metrics for civilian oversight entities, outputs versus outcomes. And so we were able to get a white paper published, and I can once we finalize it, we did a lot of work on it, and we're going to start instituting a lot of that here about the data because that's Norris's wheelhouse. And so let's see what we can do to really see how effective we are. And I think, quite frankly, the only other thing I learned was that yes, there's political influence everywhere. It's hard to get away from, and it also, for civilian oversight, the mental well-being is being stressed, just as it is for the officers. If you look at the civilian oversight practitioners, whether they be you folks, us, it doesn't matter. Everybody is seeing deaths. Everybody is seeing deputy-involved shootings. We're seeing things that to a normal person don't, you know, it's like, what's happening here? So I need to begin to focus on that for our folks here, just as law enforcement's focusing on it for their folks. And then finally, I do come away thinking that we are kind of the leader nationwide for in custody deaths and how to look at them and how to investigate them. I do believe that. So thank you folks for your support on that. And that's really all I have. Oh, and it was good to be with these folks. I got to know them and we got to talk, and I didn't have fun, Bonnie, but other people had fun. And so, no, I had a great time. It was great to know everyone. Seriously, thank you very much for the opportunity. Thank you, Chair.
All right. You want to continue on the new business?
I can. We have a request to speak, but I don't know for what item this request to speak is on. I don't know if it was for what I just said.
We don't really have, well, go ahead.
Sabrina Weddle. Sabrina Weddle.
Hi, I think I'm speaking on the next item.
You're speaking on I hear you. The public input on CLERB priorities and goals.
Yeah, sorry.
Well, Ms. Weddle, we have you on. The chair says go.
Oh, no, I'll wait.
Okay, we'll come back to you after 7B or after the chair lays this out for everyone.
Yes, I'm in.
Thank you.
Did you want to speak on,
Yeah, I don't.
come, yeah, go ahead.
I did have a question and I wanted to ask as it pertains. Thank you so much again for allowing me to speak. So I really appreciated that part you talked about going in and seeing how the booking process works. But are these scheduled? And if they are scheduled, then they aren't truly transparent.
Well, I'll answer that question. This was scheduled, everything that we do, and the chief investigator, correct me if I'm wrong, at this point is scheduled. And we understand the concerns with that.
Yes.
And we have verbalized those concerns to the department.
And I would definitely state for everyone to hear that they should not be scheduled. That is not transparency. That is a complete farce of representation. So I hope we see spot checks on this where they don't see it coming, because yeah, of course, we're going to love what we see when we're presented with what they want us to see.
We understand those concerns, ma'am.
Thank you.
We do.
But I did love your presentation. Thank you.
All right. So one of the things that we wanted to put on the agenda was we want public input on priorities and goals for 2024. I'm not quite sure how we're going to do this, but Paul, maybe you have some ideas. Maybe you would like to have people contact you and then we can discuss it further. And before I turn it back over to you, we also want to schedule a retreat for the board members for a number of reasons. Set our goals, kind of get to know each other a little bit better, discuss certain things, and part and parcel with public input, not at the retreat, but where we can discuss what the public has given us, their suggestions. And so, Paul, I'm going to turn it back over to you, and then the board. You okay? Okay.
Thank you, Chair Delaney. I think, well, number one, we have one request to speak. I don't know if anybody in person wants to speak. What I would recommend, we've never done it before, but it was mentioned earlier. There's no reason why we couldn't do some kind of press release or something like that to solicit the public's feedback and have that sent to our main inbox, and then I will collate them and bring them to the next board meeting. Obviously, you'd get them beforehand, although that is 2 weeks from now. That's the issue.
Let's do this for January. I mean, at the least, January, February. I want to give the public enough time that they know about it. They can respond. The holidays are coming up. So let's plan for the first of the year.
Understood. So that would be my recommendation to this board, that we do a press release soliciting said input. And if Ms. Hakak has nothing, any other suggestion, like anything else? No. That's what we'd like to do.
Board members, I'd like to.
I have that we go out to the community can we go out to the community, meet us part of the community, and have the community come and say, this is what we would like to see done, or meet with us and give us some ideas. I would like to see that done. If I could.
Dr. Brown, do you envision your board being there, or is this something that I and staff would be willing to do?
Sure, all of us, it'd be a combination of us. Yeah.
Okay, I'll leave that up to the chair and council.
I'll get with council afterwards. We'll talk about that. Make sure that
I'm recommending Tim Ware for sure to do that.
Vice Chair.
I think that I put this on the agenda. I believe it was my suggestion to add this to the agenda. And I'm open to hearing other ideas for how to do this. But I recommended this when the chair suggested that we have a board retreat to set our goals for the next year. I think that we have a lot of people who come to this meeting every month, a lot of family members, a lot of people who are following CLERB's activities. And I would like to know what you would like to have us at least consider for our goals and objectives for 2024, that we have that input before we go into our retreat planning. So I guess I originally envisioned that people would see it on the agenda and perhaps give us suggestions tonight. So if anyone saw it on the agenda and wants to give us their suggestions tonight, I think that they should feel free to do that if that's okay. And that would be part of the public comment for this item. That doesn't mean we can't do more. I just don't want anyone to feel like they came here tonight prepared to offer suggestions and not get a chance to do that tonight.
Did anyone come here for that particular purpose? What was that?
One of many.
That's what I guess what I wanted to say is that I feel like people probably came to tonight's meeting or participated in tonight's meeting wanting to give that input. So may we take some of it now?
That was the hope as well. We have
Okay.
one
Yeah.
request to speak online only.
Okay.
And then Mr. Miller, you have a request to speak then for this item. Is that correct?
Okay,
Chair
sure.
Dupin?
Yeah.
Mr. Miller? you're
And
up.
then for the future, yeah. Anyone that wants to send something in or your groups want to send something in, please do.
Yeah, thank you. My name is Yusef Miller, North County Equity and Justice Coalition, Saving Lives in Custody campaign. And of course, community outreach is important. Virtual town halls or in-person town halls, going around doing the what I used to call a traveling road show. You go to North County, you go to East County, you go to Central, just to do that traveling road show. And I know you can't all be there at the same time, but break it up into however you break it up. But also an online portal. So for example, something like a online what we call suggestion box, and have someone particularly filter those out, and not just the same as the website. If you have any questions, write this website. No, that's a lot of other stuff. I mean, a specific online portal, a suggestion box for goals and things for the CLERB moving forward. My personal goals that I would like to express is that more teeth for CLERB. I mean, we're trying to count teeth as family and activists that CLERB has to make changes, make differences. And I'll tell you, I've been, working with you guys, and it's been a pleasure since 2020. And I've seen teeth break out and grow and sharpen as the time goes on. Very proud and very happy of that. But we need to do more, and those teeth will help us push back when law enforcement is not as flexible or not as far-reaching as we would like them to be, to give them that nudge and push them in that direction, and to push ourselves as well. I mean, these families, they've been coming here, as you also know, since 2020, and they've been vocal and they've been online, and it's not a game to them, and I know it's not a game to you. We're here for the long haul. We're here for the seriousness of it. But what we say amongst ourselves, like you guys have closed sessions, so do we. And in our closed sessions, we talk about the need of teeth. We talk about the need of follow through. We did talk about those needs. So if we can reach out to the community and give the community, they might not have an answer for the question now. They may have to think about it and marinate on it. Not everybody reads the agenda until the night before, or the evening, or on the drive up, or somebody's telling you, hey, what's on the agenda? What are our talking points? We do that, because we have lives, we have children, just like the rest of you. We have families and stuff like that, but we're dedicated. So if to make that process easier, to give a specific portal for us to say to our allies, this is the portal. If you got that great idea, send it to the portal. Family members come up with something in the middle of the night, send it to the portal before I go back to sleep and forget. So that's one of the things.
It's a good idea. Thank you. Is that doable?
It's doable on two fronts, is my understanding. Number one, the county has an engagement portal that we are already using. We believe we are already using that. But then while Mr. Miller was speaking, Ms. Hakak mentioned that it's also something that she could probably set up as well. So you have two different options, as many different options as possible, I guess, would be beneficial. And then
Absolutely.
as far as the road show, we've been willing to do that
Right.
from day one.
Okay, I think we have another person. Okay.
Miss Weddle. Sabrina.
Hello, good evening. My name is Sabrina Weddle, the older sister of Saxon Rodriguez. I know there's a couple new people there that I haven't seen or met, but I am the older sister of Saxon Rodriguez, who died in San Diego County Jail on July 20th, 2021. my first suggestion would be the 3 minutes. You know, it's really hard to introduce myself and give suggestions within 120 seconds. I also want to start by co-signing if the booking, you know, when you guys go and you see how booking is, if it's scheduled, you're definitely not seeing what we see when we're out there protesting and the cops, the sheriffs are sitting on their ass for over 2 hours, which is something that I have witnessed, I have documentations of, and you know, it's like, what is it that they're doing? And you can't sit there and say it's a slow day when they say they're short staffed and overworked. I also want to start by also, I guess I'm not starting, but about the drug intake screening, you know, we also need to be holding the sheriffs accountable. You know, it has been found by CLERB themselves that the sheriffs were the ones responsible for not keeping the fentanyl out that killed my brother. I mean, I say over and over that Chula Vista PD sent his fentanyl home after he died. So they can't say it was my brother's drugs. It was drugs that he received while he was in custody. And my brother was only in custody for 4 days. He was booked July 16th and died 4 days later. He also could have been revived if the deputies checked him on time. And, you know, none of those deputies, Brian Powell, Andrew Randovich, Maxwell Rimple, or Andre Wanzer will ever be held accountable. You know, Melissa Burns, Reggie Barreto, Carrie Cavello, Rhea Encarnacia, Caitlin Hendricks, Marlene Abanza, Kelly Payne, Levy Sanchez, and Chantel Williams. 9 nurses couldn't revive my brother because he was already dead when they found him. And as far as transparency and, you know, looking into other deaths, I think that we should also look at these names that I have and see how many other people were in their care when they died. You know, I know my mother spoke on Kevin Mills earlier, and with the respect of the family, I think that case also needs to be reopened. Like, I don't understand how they don't have answers for things that other families have answers. And my 3 minutes is up. But again, my name is Sabrina Weddle, the older sister of Saxon Rodriguez.
Thank you, Ms. Weddle. We do not have any additional requests to speak.
Okay, so how about we establish a portal, you do some press releases, and we reconvene this topic in February. Yeah. Board members, does anyone have any comments?
I think it's a great idea to have a retreat and then obtain input before that from the public. I
Right.
think it's fantastic. And
Okay.
I do like the idea of perhaps considering going to different areas of the county where it's closer to members of the community. So
Okay.
I love that idea.
And this came out of a meeting that officers had. I was talking about the having a retreat, and then it came, Mary Ann was talking about, let's get the public input for, and so you know, yes.
Wondering if we could take like maybe some time in one of the agendas to kind of workshop it with folks in the community. I work a lot with Sandag, and we use this Menti tool. It's a tool you can use like through your phone to make anonymous comments, and you have sections, and then folks can text in. You would have to have a phone, but it's a good opportunity to like all see like what is like a word cloud of what people want. We've done that for like any transportation priorities, transportation changes or challenges that we see. I think like to Dr. Brown's comment, like it's a good way to workshop, and maybe we can use some meeting time that already some of the families come to workshop it for a few minutes. And happy to help too.
Oh, great, thank you. February, we'll go ahead and we'll start planning that.
Yes, ma'am.
All right. So we were discussing the CLERB meeting format and frequency. You know, the meetings run late. did we want to have a couple, did we want to have a meeting where we just did the closed session? And to do the cases. And so we just put this on the agenda for general comments. And of course, the community members were happy to hear from you as well on that, your thoughts. Mr. Parker, did you have any comments on that?
The only concerns I would have with having more than one meeting is it's difficult lately, with all due respect, I mean, to get a quorum.
Yeah.
That's number one. Number two, it would then be the additional time for the IT folks, the sheriff's department folks, this room, but then also our folks. You
Agreed.
folks too, I get it.
Agree.
But just throwing it out there.
Okay.
If we had a separate meeting for closed session, we wouldn't need IT.
But we would need IT if someone needs to attend remotely. Like right now, we have an.
Oh,
Can a board member,
That even allowed?
wait, is that
even
allowed for a closed session?
Yes, you can still have, as long as,
They meet the
you,
criteria.
yeah, and you would have to be able to have the platform correct.
Okay.
But yeah, you can do that.
Okay.
And just to clarify, we can or we cannot have a separate closed session electronically only. We have to meet in person.
Yes, there are
Okay.
no longer all virtual meetings. The latest one is AB 2449, which I think you all may have had some experience with. You have to have an emergency. A board member may participate remotely, but they have to have a good cause
Right.
or an emergency.
I think I might.
What about an emergency board meeting?
Well, that's, there's a time frame on that.
I'll just open up the conversation here. I think I also pushed to have this item on the agenda because of what I mentioned earlier, just that sometimes these meetings go very late. I don't want to cut anyone off if the members of the public want to speak, or we have a lot of important business to get to in open session. But then I do feel like the closed session deliberations suffer when we don't start them until 9 or 10 o'clock at night. So I really just wanted to have some ideas about what we do. And maybe it is that we do a better job of managing what goes on the open session agenda. And maybe it is that just a suggestion, we set a time certain end time for open session. And maybe that is 8 o'clock. 5:30 to 7:30 or 8 is a long time for an open session meeting. We've got a lot of families that are, I know Miss Weddle has said that she's got her son that she's trying to manage, and the families are here for a long time. I think, 2 hours should be enough time for an open session. We just maybe need to manage the agenda better for open session is my suggestion.
Mr. Parker.
Thank you, Chair Delaney. I agree. I know that our sister agency now, the Commission on Police Practices in San Diego, has a hard stop time, and whatever they don't get to, it's not that they go to closed session and come back. My understanding is they don't get to it, they don't get to it. It goes on the next agenda. But to your point, having less on the open session agenda will probably go a long way to making sure that we can get this done.
The other thought that I'm sorry, Bonnie.
I just wanted to comment too, having a hard stop I totally agree with that. But whatever's left over gets pushed to the next, it's going to just keep going and going and going. That's not a solution, unfortunately.
So I'm thinking that maybe I want to hear the public. That's very important for me to hear what the public has to say. But I know that some organizations have gone to 2 minutes per speaker. Yeah, I'm thinking maybe let's try that and see. I know that gives you the opportunity to speak, but it also gives us the opportunity to be a little bit awake when we're doing the cases. Trying to find a compromise, because again, if you have a hard stop, you're going to just move everything over and everything is going to continue to. So I would be willing to maybe try that, and let's see what happens with that. What are your feelings? Oh.
Thank you, Yusef Miller, North County Equity and Justice Coalition, Saving Lives in Custody campaign. I would be absolutely against lowering from 3 to 2. As a matter of fact, I would propose from 3 to 4. But the way I would crunch the time is maybe some of the reports can be actual reports and not a discussion. You send among yourselves electronically. You can discuss back and forth electronically and slim down and narrow down some of that by some of the reports. I think some of the report topics, we're here talking a long time about it, and maybe it just pertains to the rest of you, and we don't really have anything to do with it. We don't have anything to say about it, but that's great. But does it have to be here? So I would look at that and try to trim some fat on that one. I've done that in some of my other organizations where I'm like, look, this could have just been a flyer. You know what I mean? You could have just sent this to me, instead of talking about it for a very long time. So that's a suggestion.
I think the only concern I have with that is I don't want to violate the Brown Act, and what we do has to be done in public. So we can't converse back and forth electronically.
But I mean, there's somewhere you can do something. I think there's just opportunities somewhere. And I was going to say that just to absolutely not on a 2 minutes. I mean, we struggle to get in what we have in our emotions and our topics on 3 minutes, and the 3 minutes go fast. To me,
they do.
So let's make that a non-option or a very, very, very last option, close to non-option.
Okay.
So thank you.
All right.
Mr. Miller, he brings up a good point in that most of our speakers, they come here prepared and they speak their piece and they get cut off at 3 minutes.
Yeah.
So why can't we do the same thing for ourselves?
You're cut off.
Give ourselves.
Nope, I'm sorry, you're cut off.
Give ourselves a hard stop.
Yeah.
And we
That's
stop.
it. You're done. Okay. Yes.
Are we able to have like a time frame for like presentations, reports? Because that's what I do in my meetings. Like you have 5 minutes to report back.
So we have a
move
time
on.
sensitive on each agenda item.
I think so. I think that helps with the
Let's
time
try that.
management. And
Okay.
then I wouldn't want to cut time from public speaking.
Okay, so how about we do this, Mr. Parker, when you prepare our next agenda, we'll discuss give us some ideas of the time that you think it will take, and we'll discuss it. And we'll see what.
No doubt about it. That's a great idea.
Okay.
We have one request to speak on this topic.
Okay.
Also from Sabrina Weddle.
Okay.
We just called.
Did you, Hank, we have somebody online, and then we'll come to you.
We'll come to you, Ms. Weston, in 3 minutes or less. Ms. Weddle.
Hello. I just want to start by saying, yes, I do have a son, but he has never been an excuse that I need less time to talk about my brother, or any of the matters that are presented during CLERB. I definitely think, I heard a suggestion, having maybe structuring it a little bit better as far as what is presented. We can also start by, holding the sheriffs accountable for the deaths that they keep allowing to happen, which is your guys' caseload, and half of the topics that we talk about. We need to end qualified immunity so that they can stop doing what we're talking about in these meetings. Change needs to happen, not let's shut the family members up, give them 2 minutes. I mean, I was just saying 3 minutes is hardly enough to introduce myself, let you know who I'm representing and what I want to see. I mean, there was just another death. I didn't even get to mention that in my last 3 minutes. There was another death. And they, again, we tried. Yeah. How many times have they tried? And again, another person having to bury a family member right before the holidays. It's 2 years. This is my second Christmas, my second Thanksgiving without my brother. And change is happening, but slowly. And the change doesn't start with eliminating our time to speak. It starts with who's bringing in the fentanyl, who was responsible the day that Saxon died. for the fentanyl that keeps coming in. Again, you guys went to see the booking intake, but let's go see the process of them clocking in for work. It's ridiculous. I was out there a couple weeks ago, you know, with a reporter, and we got so many pictures of deputies letting other deputies in, didn't need their badge, with bags full of stuff. Again, is it Chipotle or is it fentanyl? But who knows? And I'm glad we can laugh about it, but it's a real fucking question. My brother died from somebody doing their sworn duty. That's why we're here at these meetings so late, and my son will never be an excuse as to why we need to end it quicker. Because he's on the Xbox having a ball right now. Good time, for sure. But that doesn't mean I want less time to speak about this. Thank you.
I think I've heard you loud and clear. It was just a suggestion. We will not be limiting your time. As I've said many times, I want to hear what everyone has to say. Just throwing things out there. And thank you for letting us know. Did you have something that did you want to say something? Okay.
Ilka Weston again, thank you so much for hearing me out. Obviously, I feel strongly that actually it's a good point. You do want to close it earlier because we want you to be in right mind when you're discussing things that are so vital and important to us. I think cutting somebody off during an emotional plea to be heard is impossible. If I was up here talking about myself and the pains I've suffered, I would be in tears. I'd have a hard time finding my words. I wouldn't know what to do. But usually when I'm up speaking, I focus on helping others because that's how I deal with my pain. So doing a hard stop at 2 minutes is very easy for me. And I think it's vital that I heard a lot of information going on in this room, which I loved, you know, because it's important to understand Robert's rules. But there was also a lot of dialoguing that probably could have waited, that wasn't as vital for the closed session, because it's 8 o'clock now and we're now just starting on the issues that are on the agenda. So thank you very much. And
so let me explain something to you, just so that you know. Our business has to be done in public. We cannot discuss any of this in closed session unless it's on our agenda for the closed session. So that's why it's taking a long time, but even though it's tiresome, it's important.
that I do agree with, but I was listening very closely and I have been very active in a lot of groups and organizations. That's why I don't say them all. You know, I just say my name. The important part that I noticed is if we have a time limit, there should be a shorter time limit for the casual conversations about something that we want to hear about. And I noticed a lot of dialoguing going on that could have taken time away and allowed us to start on the issues.
Fair enough.
You know, we all have to look within, and thank you.
Any other comments?
I'll throw a few comments out. One is I would like to just start with saying, of all the meetings, public meetings I've ever attended in my life and boards I've been on, this board is the most agreeable to public comment I've ever seen. And I think that that's a testament to the chair. It's a testament to our leadership team. I mean, it's truly, most I've ever seen. I've been to city council meetings and other meetings where, you know, it's definitely not open to the public, I assure you. So I've seen it. So I want to praise the chair and our leadership team. But with that said, I do agree that the agenda, what's on the agenda and the amount that's on the agenda certainly impedes us from getting to closed session sooner. I think the second thing is I love the idea of setting time for presentation. And by the way, we should have a informal idea for board discussion after that. And I think that we should know, hey, 5 minutes on that for discussion is probably good, right? And we should all kind of understand that. And that's something we could probably discuss in our retreat, is how we'd like to look at that. But those are things that's what we've done on other boards I've been on, is when someone presents, it's 5 minutes. It's 5 minutes, and that's what you've got. And then the board can ask questions and then the public can comment. So that I love the idea of that. And so I think those are all some of the key things that because when you really think about it, if we're going to shave off time from public comment, well, what's 1 minute when we only have, if we only have 5 or 6 speakers, right? So to me, it's about, I want to make sure everybody's heard on every aspect that they want to share with us. So I think all that's to say, I love the idea of the agenda. I love the idea of, and also perhaps separating stuff into workshops or other things that we may want to talk about. So just some thoughts.
That's not a bad idea. We have some of the unfinished business or some of the new business. Maybe it could be consolidated into bullet. To think about that. Yeah.
A concept that I've used many times in my school district is when we have a really in-depth discussion. Sometimes it needs to be, by the way, all this is very important work. And so all this meeting of the public and the board. And by the way, I think Robert's Rules of Order and I think the things that we talked about earlier are critically important for the public to know how we operate. And so I think those are really important pieces of education. But sometimes we do those in board study sessions and other things where we dedicate it just to that topic. We've done that before as well.
I think there's a lot for us to think about and work on. Thank you, everyone. I'm going to turn it back over to you regarding the updated proposed revisions for materials.
Thank you, Chair Delaney. Basically, I'm not going to recap everything else that you folks have already authorized me to move forward with for the rules and regulations revision and the code revisions. All I want to talk about tonight is the establishment of a time period for receipt of requested materials from the departments. But what I want to add to that is if we're going to hold them accountable for some time limitations, I need to hold myself accountable too. So there are some things that I need to do and that our administrative team, once Amalia is up and running, need to do in a more timely fashion as well. So to be transparent, what I was proposing to this board was when we ask the departments when we get a complaint from anybody, we make a request to the department for materials. We contend that absent something that's a criminal investigation, a death case that's reported to us, absent that, we contend, and we could be wrong, and the departments could chime in, that those materials should already be available. We're not asking for something that's not been created already. So what we would like to see is perhaps, I know that the city's board has something now in their charter that says that the department has 10 days to get the materials to them. Now, that might be a little too quick. So I was just going to throw out there to you that when we ask for materials from the respective departments, what time frame would you think that we should get the materials back? I give you this. First, I will say the current team that we have, led by Lieutenant Perkins and his folks, are doing everything they can to get us the information in a timely fashion. I had a conversation with the lieutenant before this meeting as well. He is committed to getting us things in a timely fashion. That being said, we still have some things that are outstanding for a couple of months, right? But they're still waiting for me on a couple of months for some basic letters like sustained finding letters or whatever the case might be. So I get the staffing shortages. I get all of those things. However, I do think there needs to be a time limit on this, like just throw something out there. Policy recommendation response. This is something the vice chair brought up probably almost a year ago, to put some kind of time limit on the policy recommendation responses we get. To be very clear, we don't want to force the department to not respond to us because they don't have to. But I think the vice chair will correct me if I'm wrong, 60 days at most to respond on a policy recommendation that we make. And even if there's nothing to say, because it has to go through various changes, chain of command, and we get that. But at least to give an update every 60 or something like that. So this would be my proposal to see what the board thinks is a reasonable amount of time, if the board's even interested in doing this, to add to, at minimum, our rules and regulations. And I would like to see it in the code, quite frankly, because that's the only way we can hold the department accountable for getting things back to us in a timely fashion. With that, hopefully that makes sense, Chair Delaney, what I'm asking. But again, to be fair, I think that something needs to be put on us in our policies, our internal policies, that when the board says, okay, we have a sustained finding, I get the sustained finding letter to the department within a week or something like that. So things like that we can deal with internally in our policies, but for the departments, I think it should be more concrete. I turn it back to you, Chair.
Okay. Bonnie.
I just wanted to comment. The grand jury gives the departments 90 days to respond to the recommendations. They also have an auxiliary group, which we could form to, if the recommendation is agreed to be implemented, they have a committee that oversees to make sure that those recommendations are actually implemented. I don't know if that's feasible for us to do.
That would be above our jurisdiction, right? I mean, to sit in and make them, you know, I mean, if the board wants me to pursue that as part of the rules and regulations or code changes, then so be it. But yeah.
Lieutenant, I don't want to put you on the spot, but could you give us a very, very brief synopsis of, you get a recommendation from us. What's the process then? Thank you for letting me put you on the spot.
No problem. I'm sorry, you're talking about a policy recommendation. So typically, we get the policy recommendation. It depends on what it is. Some of the things entail a lot more research and work than other items. But then in my office, Division of Special Services, we go about finding who the subject matter expert is to see if we think the policy is feasible. And then we look into it and we will draft a response, and that response will go through several layers of review. A lot of times there's suggestions added that weren't thought about before, and it sometimes gets kicked back. But some depending on what the policy is, it could be quite a bit of research. So,
And does your legal review it as well?
yeah, everybody from command staff to sheriff's legal has input, because any policy could affect,
Right.
yeah, liability and stuff like that.
Okay, thank you.
You're
Appreciate it. Mr. Parker, what was your suggestion?
Well, again, I could be wrong, but I believe that the CPP is 10 days. Yeah, I think that might be a little. Yeah. So at minimum, I would think maybe, 14, maybe 21, nothing more than 30. Whatever you folks decide. I think that the materials exist absent a death case. Those do not exist. But I think the other materials that we're asking for do exist. It's a matter of the department tracking them down and getting them to us. So.
Lynn? Can you turn your mic on? Yeah. Yeah. Thank you.
Saying, to clarify, it's two separate things, the document request versus the policy responses.
Okay.
And I was addressing the document request.
You were
first.
yeah, you were
Mhm.
And the document requests would be examples.
Go ahead, Lynn.
So when we receive a complaint with allegations, we're requesting all documents associated with that. So it could range from a few things to various things, and it could cross through detentions versus law enforcement. It just depends on the nature of the complaint. It can be very involved or minuscule, just depending upon the allegations associated with it.
And let's say it's a death case. What time? I'm
Well,
going with
are different because we
yeah.
subpoena those
Okay,
records.
let's go. Let's do a more complicated case that's not a death case. What? Okay.
Let's do an excessive use of force.
Okay, yeah.
Something that actually has a complaint.
Okay.
All right. So for that, we would ask for any BWC, any arrest records, the dispatch detail, the audio recordings of the dispatch, the CAD recordings as well, the CAD printout, any evidence, you name it, we're asking for it. And if the person was subsequently booked, then the booking information and whatnot, right? So I think that's fair. And so that's a priority investigation, but something that has a complaint that's not told for any reason normally.
Right.
Okay, so using that as the guide, what's the question?
So the question is, and what do you think is a time frame that you would like to see that so you can continue your investigation? Sorry to put you on the spot.
It's okay. And Dave, you can correct me if I'm wrong with this, but routinely, I think that responsiveness has been within 2 to 3 weeks routinely. But I think there's some disadvantages that the department's working with right now with staff shortages and so forth. It depends on the level of expertise with the liaison, if they're knowledgeable in detentions or not. That has an impact because they're farming it out to other people. So this really is a lot of it that if they have to farm it out to other people on the response time to get it back to their department, go through it and then respond to us. But I think routinely 3 weeks has been somewhat manageable.
So 21 days. I think that's fair. Board? Is there? That's a good question. Yeah, no, that's a good question.
For me, I'm with 21, I'm gonna do calendar because then I'm at 4
Calendar.
weeks and 1 day.
All right.
Yeah,
Do we have
yeah.
a motion? Go ahead, you can make a motion. Someone want to make a motion that GI? 21 days? I think it's a calendar. Okay, so 21 calendar days. We have a second?
I'll second.
Any other discussion on the motion?
I got a discussion. You say 21 calendar days, you mean work calendar days or 21 days period?
Days period, calendar, on the calendar. 21 days period, including Saturdays and Sundays.
Hey. That's just a question I had.
Yeah. Was that your intent? GI, have your motion?
Is it 21 days period?
Okay, was that your intent of the second?
Yes.
Any other discussion? Could you roll call, Secretary? Okay.
Chair Eileen Delaney,
Yes.
Vice Chair Marion Pinto,
Yes.
Secretary Bonnie King, yes. Dr. Arlie Brown,
Yes.
Andrew Hayes,
Yes.
Nadia Keene, yes. Ariana Pedrigo Mondragon,
Yes.
Tim Ware,
Yes.
D.I. Wilson.
Yes.
Great. All right, now we'll go to unfinished business. I will turn it over. No.
Policy recommendations now. The response for policy recommendations,
Oh,
the time period for that.
okay.
Oh,
Sorry.
right.
And then also,
Did I miss?
if you folks want me to create an internal policy, which I'm going to do, I'm gonna tell you right now, I'm gonna do it.
Let's see that on
To
the
get
agenda.
sustained finding letters, policy recommendation letters to the department within 7 days of the meeting. So that,
It's not on the agenda.
what's not on the agenda?
Policy recommendation.
No, I know. I'm telling you that that's what I'm going to do.
Okay.
All right, so that, because I want to make sure that everyone knows, I'll take accountability for it as well. But back to the policy recommendation part. That's the requested materials from the department.
Oh, in other words, you're gonna make that a policy. Yes. You're gonna make an item that says the 21 days.
No,
No.
no,
Am I
I'm
missing?
sorry.
I'm
I
saying that-
interpreted, my definition of requested materials did not include apparently policy. It did for me, policy recommendations, because we're asking for the policy recommendations. What I meant by this was 2 things.
Both things.
Right, but if it's not clear, I can bring back the policy recommendation for next time.
I will ask counsel.
I think it's probably okay because he's just clarifying the scope. And a broad reading of CLERB's rules and regulations in San Diego administrative code and
Okay.
then the requested materials.
Okay.
My apologies for any confusion on that.
I will go ahead and make a motion that it be 60 days to start the discussion, if that helps.
And can you clarify what?
I would move that we request or we establish update our rules and regulations to establish a time period for receipt or for response to policy recommendations, and that time period be 60 days. Or no more than 60 days,
No less than.
Calendar days, ma'am.
calendar days.
Is there a second? Discussion? The problem is that you made the motion before we had, how do we deal with this? We didn't really.
I thought
talk-
we had to have a motion before we discussed it.
No, we can only
Okay.
discuss the motion that you made. We have to have a discussion and then make a motion. Could you withdraw your
I will withdraw it.
okay, and will you withdraw your second, please? All right, now we're gonna have a discussion on the number of days. Go ahead.
I think 60 days is not enough time for them to go, oh my God, how do we respond to this?
So you think? I think 90.
I think when I originally suggested 60 days, my intent was that if they did not have a fulsome response, as in here's our decision or here's what the new policy will be, that they at least report back to us that here's where we are, here's why we don't have an answer yet, or maybe that doesn't make sense to do it that way, but I just felt like sometimes we make these policy recommendations and they would stay on the agenda a long time with no response, and we don't really know if it's fallen into the ether or, I think it would be helpful for us to know that they are working on a response, if that makes sense.
Could we do something like some type of update within 60 days, but the policy recommendation within 90? I'm just throwing it out there.
I don't see a problem with 60 days. If they have a whole different division of people that handle this. In 60 days, we take from the moment that we see a problem and we suggest something, we're now putting it forward and taking it back to the sheriffs. At that time, there could be other people with the exact same problem. Are we going to allow 60 days to turn to 90 days while people are experiencing the same issue? I think 60 days is appropriate.
I have a question for the sheriff's, for Lieutenant again, sorry. When we make a recommendation and you say, yes, we agree to that, let's just say, how long then before it's in part of your policy?
That's a good question. It depends on a lot of factors, but it goes through, there's no set time, but it goes through several layers of review. But we try to get it implemented, as soon as possible, usually within, if it's determined to be approved, that it's going to go forward, we usually try to get it, the process, we try to get it done within 60 to 90 days, sometimes 30. It just depends on, people's availability to review it. And it goes through a lot of hands because policy is going to last for many, many years. So we just need to make sure that, but we try, once something's approved, we try to get it done as soon as possible.
The policy recommendation that we put forward to have you scan the officers as they enter, how many people did that enter with the response that they may get cancer?
I'm sorry?
The response was that your concern was that the officers would be exposed to cancerous rays. How many people did that go through?
I'm not sure, hold on, I'm not sure that we can actually, we're not talking about a specific case. Is this okay?
No, but it's to establish what happened. This was something that we put
Yeah,
forward
I just want to
before,
make sure
right?
we're okay.
And I just want to be able to establish.
Chair Delaney and Member Ayub, I think if we're speaking just as examples, so you all can intelligently question and discuss, I think it's fine as long as Lieutenant Perkins can answer the question or give a good.
So I'm sorry, are we talking, I'm sorry, thank you for clarifying. Are we talking about a specific letter or are you talking about it in general?
It was the recommendation we made to have the officers scanned as they entered the jails. And the response was that that was not appropriate because the officers would then be exposed to cancerous rays.
To be quite honest with you, I wasn't part of that letter. I came here in March and I think that was drafted the year before at the end of the year. So I wasn't involved in that process. I can't tell you, the response on that one.
If I may interject something, from my experience in risk management, when he says it's a liability issue and all that stuff is involved, I'm just being honest with you. It's going to take, the county is going to look at it, the insurance company is going to look at it, everybody's gonna say, hey, what's our exposure here? And it's gonna freak them out. It depends on what the matter is, depends on what we're asking them to do and how we're going about it. It depends on how serious it is. So somebody can always come back and say, well, wait, you putting me, you hanging me out on a limb here. You know, so ultimately the insurance company or whomever at the top gonna say, look, you can do it, but you're on your dime if you fail. So.
Understood.
If I may, just so you are all aware, I think hopefully Mr. Parker can vouch for this, but I think those of you that know, our department, know the sheriff, she's very clear. We give thought to a lot of our responses. We don't just try to crank them out. And sometimes they're very lengthy. We try to explain things. And I don't have the statistics, but I think Mr. Parker does. I think something like half of the recommendations you've given us, we've agreed to. So we're always very amenable to make changes where we can. Also say just sometimes it also depends, right? I think 1 year CLERB gave us like 40 recommendations. The amount of work that goes into that, it's a lot. It takes a lot of time. I have a unit with a lot of people, but we have one sergeant whose full-time job is to be the CLERB liaison. And I had that job for 3 years when I was a sergeant, and I barely kept up when it was just Lynn and one other investigator. And that was before the days of body worn camera and a lot of other things. And now we have 6 or 7 investigators and all the other things that are, so I commend these guys. But I will also tell you, Lynn or Paul can tell you, my phone is always on. I always answer it. I meet with them regularly. And if there's ever an issue, they know they can call me and I will make sure whatever they need gets done. So.
And I do appreciate you letting us put you on the spot here to gather more information. Mr. Parker, did you want to?
Yes, thank you, Chair Delaney. I can vouch for everything the lieutenant just said. He inherited, he came in after the 40 policy recommendations. He inherited that. We did slow down the policy recommendations so that they had an opportunity to get caught up. I do know that the lieutenant and his folks are actively working on getting them caught up. I believe that that's what's happening in my conversations with the lieutenant. And I believe that the 7 that are outstanding won't be really much of an issue much longer. We're going to have some responses very, very soon on that. So I do vouch for what he just said.
Would it be realistic to say 60 days? However, if you're not completed with 60 days, 90 days with letting Mr. Parker know, Mr. Parker, would that?
What I would ask that the motion, if I may, clarify 60 days, not from the date that you folks say, okay, Paul, go forward. 60 days from the moment they get the letter from me saying that you folks said to go forward. And previously, that has been some, okay, so 60 days from the time that they are noticed, they received the written notification that CLERB approved.
Right.
Then 60 or 90 days, whatever you folks decide.
Is that real? I want attention to be paid to our recommendations.
Obviously, Sheriff's Department, CLERB is CLERB. We can't tell you. I will just tell you, having done the job and managing the unit, a lot of work goes into it. So I would say the more time, the better. But either way, I think it's always good to have any kind of policy to have, a provision that says, if something comes up, notify the executive officer, because there's always exceptions. I mean, stuff happens all the time.
Sure. And again, I want attention paid to our recommendations. So
before we make a motion, I just want to make a comment. Is that from my perspective, let's assume let's assume that the outstanding responses are not there. Let's assume a clean slate of everything that we're looking at, so that there's no catch up involved. There's nothing going on like that. What would be I just want us to consider this as we move forward. What would be a realistic time frame that we could set a standard for? That's the first question. The second thing is, and this is just for us to think about, is we don't want to do so much to discourage a response. And look, we don't have to like the response, my friends. We don't have to like the response. And many of you don't like the responses we get. And that's why we resend them. And we've done that. We've done it at least 2 times I've been on this board. So, we have tools at our disposal. And I just want to encourage us to have a relationship with a department that encourages them to work with us, not to say to us, no, we're just not going to respond to you with anything. So, my thought is that, in the event that they needed more time and a clean slate, let's assume a clean slate, they can notify Paul. And then perhaps they can say to us, well, hey, here's why we need that. And then we say, thanks so much for that update. That's really helpful. And then maybe it turns into 90 days at that point. I don't mind that idea. That's an idea. And I don't mind the idea. So I think when I look at it, I just want to encourage dialogue like we're having. I think it's really important. But I also want us to frame it so that we're not looking at it just through the lens of, well, we may not like the response that comes back. Of course, we're not going to like every response. That's the reason why we're here. So, I think that we have to look at all those things and then have the discussion among ourselves about what we want to do and if we want to challenge a policy. So that's just a comment I want to make before we move forward to a motion as we think about this issue.
Agree. Mr. Parker?
I agree with Mr. Hayes. I also think it's good to put something in writing in case we don't have a responsive lieutenant, in case the executive officer
Agreed.
is no longer here, that these things are put in place so that they carry forward and that they are reasonable. I couldn't agree more.
Okay. So go ahead and reiterate, add.
I think my original motion was that we establish a policy that the sheriff's department report back to us within 60 days on a policy recommendation that we make. That's a report back. So let us know where you are, that you're looking at it, that it's going through, what phase of the process it's going through, with the caveat, I don't know if you want to help me with the language, with an additional 30 days to complete the recommendation.
I'm all good with most everything you said, with the exception of the first part. It's not a policy recommendation. It's not, what we're looking to do is to add something to amend the code, right?
Yes,
Because
but
we
it's
can't-
related to the policy recommendations we make to the sheriff's department.
Correct.
Okay.
Correct. But as long as we know that
We are
It's-
amending our
that nothing
rules and
goes-
regulations.
right, nothing
Correct.
goes into effect unless they do it
And-
internally
correct.
until it goes to the rules and regulation and admin code, meet and confer and all that. Okay.
Correct.
So
Correct.
maybe
It's a
another.
recommendation.
Okay,
It's
got
a
it.
response to our recommendation.
Perfect. Thank
Yeah,
you.
yep.
So
And that 60 days and 90 days begins after the sheriff's department receives the recommendation in writing from the executive officer.
Okay.
I think that gives some
GI?
flexibility. I
Is that a
think.
second? Okay. Okay. Any discussion on the motion? Okay. Yes.
Yes.
Dr. Brown? Yes.
Yes.
Nadia United? Ariana Pedro?
Yes.
Where?
Yes.
G.I. Wilson?
Yes.
Great. Thank you.
Making a comment real quick,
Yes.
just real quick, the process we just went through, if we would have put a time limit on that process, that's what we're talking about. Put a time limit on that process, we would have got the same results in 5 minutes.
We're going to put you in charge.
Teamwork.
Teamwork. All right. Can we go to unfinished business now?
Are we gonna have a bathroom break?
Yes. You have 2 minutes.
All right,
Just
time.
kidding.
So the overview, 8A, the overview of the new CLERB independent study. What we determined last month when we first went through this was that the county considers this an audit. The sheriff's department has responded to say that they will cooperate in providing information as long as we follow we request the information via Public Record Act. So that is what we're going to do for now. We'll see how that ends up. And if there are, hopefully the department, if we have additional questions, maybe they make someone available or not. I don't know. We'll see as we move forward. That's 7A. 7B, the department's I apologize, 8B. The department's command staff has looked at our detention facility inspection handbook that was drafted several years ago, updated recently. They have no additional concerns or requested changes. So we will update that. We have asked the sheriff's department to, we want to begin the inspections mid-February to the end of March for all 7 detention facilities. That's going to be falling specifically on Special Investigator Aldridge. And so that's where we are with that. CLERB jurisdiction 8C, CLERB jurisdiction expansion over medical service providers. I have made several attempts to reach out to SEIU to request. I think we all recall that right now we are simply waiting to move forward. Now, December 5th, the new board of the new supervisors will be sworn in. We're moving forward with all the rules and regulation revision proposals that you folks have allowed me to do to begin to see what sticks. And the medical service providers is one of them. If you recall, the union asked that I meet with them. I volunteered to meet with them before anything, just to hear their concerns and answer any questions and clarify some issues. I made several attempts to reach out to them to meet with them, and I have not heard back. I did hear back a couple of emails ago, but not recently. And then finally, 8D. I will, this one's going to take me about a minute. I apologize. But there were a lot of things that we covered for the probation department. There were concerns raised about probation and probation. I think the verbiage was flying under the radar or whatever the case might be. But I can tell you that we've been working on probation issues. We've been having numerous conversations with the probation department since January of 2023 on many issues. And the update to the items is, at this point, we are just about at the court order for adult records, just about signed. Ms. Gross has been working actively on that since she's been our counsel, just about there, very, very soon. The anonymous complaint, to be clear, we have someone who volunteered to sign that complaint, to take that complaint and sign it and put it forward to the department. And we were about to do that. But we also had a community member who stood up and signed the complaint reference to the possible overdoses at the East Mesa Juvenile Detention Facility. We requested materials from the probation department. The probation department responded and said, thank you, but basically, no thank you. The person who signed this has no personal knowledge of this event. It's only from media accounts. So therefore, we're only going to tell you this, which is basically what was in the media, basically. I contend, I don't know who wrote that response or whatever, and that's great and wonderful and all that, but that's the whole point of our board. That's the whole point of having an aggrieved. We don't need personal knowledge. Whoever signs a complaint doesn't need personal knowledge. That's the strength of CLERB. But at this point, the probation department is elected to take that route and not provide the information based on that. So our counsel will be working strongly in this issue.
Yes, I've started a legal opinion. What I've found so far, I'm in the process of writing up, but my initial legal opinion is that CLERB, nothing in CLERB's charter provisions, the administrative code, require any personal knowledge. It requires that the complainant sign the complaint to the best of their knowledge. That does not mean personal firsthand knowledge, and that they sign it under penalty of perjury, which is to ensure that there are no false claims or complaints made that are knowingly false to the person making them. So that is likely to be the outcome of my legal opinion, and you all will have that shortly.
And so next, the serious bodily injury definition, if you recall, we brought that up, that there's some kind of confusion about what exactly that is. They want clarification on serious bodily injury, because when the use of force results in serious bodily injury, not only is it reportable to the state by the probation department, it's reportable to CLERB as well. We have had 0 since we invoked this jurisdiction in December of 2020. And when I look back at the DOJ site, they have reported 0 uses of force resulting in serious bodily injury as far back as I can tell. But that is because there's some kind of issue with the definition of serious bodily injury. I'm asking Ms. Gross to step in and try to assist me moving forward to get a resolution on that. The Probation Officer Association has responded to me to basically have the same meeting that we had with the Deputy Sheriff's Association this morning. So I'm waiting for dates and times from them. They've been responsive. They responded the other day. So I'll wait for that. And the last thing is the probation department has a policy 8.12.15 entitled In Custody Death Review. And if you folks remember right now, and Mr. Miller mentioned, a death in Los Angeles, there was a death here. Alan A. was a 16-year-old who had who overdosed. And we presented this case to the CLERB. Two of the probation officers are on leave, so that's still told. So it's still kind of hanging out there, those two officers. However, Investigator Clue as we told you, our focus will be on the policy and procedures for the probation department, came upon this policy that says in custody death review. In the event of an in custody death, a review committee must review the incident within 30 days from occurrence. The committee shall include, this is the probation department policy, and it lists a bunch of people, none of whom are attorneys. So I don't, so there's no attorney-client thing that's at least, and it says upon completion of the review of the probation department, quality assurance specialist shall complete a review report for the chief probation officer, assistant CPO, and DCPO of institutional services. Very well. So somehow there's a report. Where'd it go? Investigator Clue asked for that report. And the response that we received was the only responsive records to your request is the BCIA Form 713 that every entity completes for an in-custody death. So they gave us the BCIA 713, which we had already had for Alan A. We then asked 2 or 3 additional times to be clear, what does responsive mean? And unfortunately, the only information we're getting back is this is all I can give you. So we don't know if this report exists. It sounds very similar to a CLERB report, or the stance being taken is CLERB related. We don't know if SB 519, when it goes into effect, will impact this at all, but we have asked Ms. Gross to assist in attempting to get additional information on this. So that's where we stand on the update. I'm sorry, I went over 2 minutes.
Do we need to vote on any of those things?
No,
Those
ma'am.
are just updates. Okay. Do we have any community? And what was your name, sir?
I'm making sure the public knows as well. Yusef Miller, North County Equity and Justice Coalition Saving Lives in Custody campaign. And as far as A goes, the inspections of the jails, I want you to please look at the BSCC's report, the Board of State and Community Corrections. They have a list of non-compliance of San Diego County and all the counties. But in your inspection, that this should inform you when you're looking at what's going on in San Diego County. Why do I say that? I say that especially because of, I'm going to jump to C, because just recently we had a 13th in custody death, and that person died in the hospital from a heart attack. That's what the report is. But the person they went to the hospital not because of a heart attack, but because of a fall. This person fell in the jail, had to go to the hospital. This person is also 71 years old. And we know that the ADA non-compliance for disabilities, our jail has a problem with that. So the question becomes, did this person who died, the 13th death, did he pass away from complications of the fall? And now it's termed as a heart attack and we're missing something really critical that could lead to other people's deaths? This person, again, 71, fell, went to the hospital, and later died of a heart attack. Was it exacerbated by the fall? So with the jurisdiction over medical, we need to make sure that we can follow up these complaints. Like I said before, there is a case right now where some families are reaching out to me and the loved one is still living. But when they were in George Bailey, they had seizures, just like one of our other family members who fell and went into a coma. And this person has seizures, many falls. They didn't give him his proper medication, and he had a concussion. They said, "Oh, you have a concussion?" Yeah, from the falls. And now his seizure medication has been increased. Was it from George Bailey? We need to know. We need to know. I reached out to the department. How is it that we report, or people report that they're being neglected medically? They said, "Oh, well, they just reported to the medical staff." Oh, you mean the ones who are neglecting them? They reported to them? Oh, what a system. And they said all inmates know the process. The inmates are calling me. They don't know the process. I've talked to other people who are inmates. They didn't know the process. We really need to get a handle on that issue. And back up to, I think I covered them all. See, that's the thing. 3 minutes. Yeah, we got to keep it 3 minutes.
Well, you'd actually have
Okay.
3 minutes for each topic. So you got 12, right?
Yeah, I was hoping. So So subhanAllah. So this is really important about this work that we're doing. We need to look at these other sources. The BSCC, I can't say that enough. And I want to add one quick thing to the young lady asked a question earlier, and the it was really earlier, so you might not remember. But the 14th Amendment for in custody people, how they're treated, and Title 15, the state code of Title 15 will answer some of your questions on how the basics, the food, water, health, and all those kind of things. Those are the things that are being violated, and that's why we're here. 14th Amendment and Title 15 of the state code.
I think we have one other. Yeah.
We have Sabrina Weddle.
Okay.
Miss
We
Weddle.
also have somebody in person.
Hello. I'm just going to be real quick just to follow up with what Yusuf said. We definitely need CLERB to have jurisdiction over medical. You know, you guys have heard firsthand one of the nurses that was responsible for my brother, Melissa Burns, come onto CLERB and state they shouldn't be, you know, overseen, and that if an overdose were to happen at a jail, that's the best place to get treatment, when instead her statement should have stated there shouldn't be drugs in jail. They shouldn't be allowing drugs to get into the facility. Unfortunately for my brother, Saxon Rodriguez, jail wasn't the best place for him to get treatment from an overdose. The best place for him to get treatment apparently is at the park, where a ambulance had to locate him, find him, and administrate, you know, Narcan and everything to revive him. And he was revived at a park a month before, but yet in a facility where there's 9 nurses, they couldn't revive him. And, you know, I'm going to say those nurses' names every time because all I have is their name. They're not ever going to be held accountable. My brother's still dead, and that's just what it is. And we need CLERB to have jurisdiction over them. Again, I replay Melissa Burns stating that statement over and over. This is somebody who treated my brother. The nurses are still mad to this day. I have their name. And for transparency, CLERB was not who gave me their names. It was my liaison, who's no longer my liaison for my family. But that's all I have to say.
Thank you, Ms. Weddle. We do have an in-person request. Ms. Weston?
Thank you all again. And kudos to you for bringing up the fact of the need for our officers, deputies, and whatnot. They do need to be walking through a check of the scanning. You know, we go through it when we go to the airport. What are they better people than us? The deputies, the sheriff, the police. But I did want to go over this. I'll have to put my glasses on. Sorry for the dark shades on here. I do love the idea that these are all approved and you're going to be moving forward with these. I'm very excited about that. On B, I definitely think one of the main issues you definitely have to bring up is, for transparency's sake, they have no idea that you're coming in to do these checks at all of the detention centers in San Diego. The other issue I really wanted to bring up, I was very sick this year, so I had to have repeat trips to the hospital. And interestingly enough, I noticed people in other rooms that were potential to be arrested or brought in from a jail or one of the institutions in San Diego County. And it was very interesting what happened to the other people in the emergency room. The reason why I bring that up, we talk about a man who took a fall and had a heart attack. What happened prior to that? And why isn't that in their record? And it does happen because I witnessed it myself. And when I bring that also up, I was a victim of very severe domestic violence in my housing where I was living. And there was a CPO granted, and the DA was talking with me, and the DDA, because I know the DA. And the reason why I bring this up is because when the gentleman in question came back at me, the sheriff's department neglected to put the CPO in the system. So they did nothing the second time they came back. And I got an apology from a sergeant, but they did nothing about their errors or their mistake. So I don't think they release all their paperwork. And that concerns me. They need to do better. And thank you very much. And I'm sorry it took a little longer. And again, I'm looking forward to you moving forward on these. Thank you for all your hard work, all of you. And happy birthday, Marianne. Somebody had to say it.
You look pretty good for 29. All right. Oh, yes. Okay.
Next, we'll call Paloma Serna.
Hello, yes, thank you once again for letting me speak. I want to echo the exact same thing what Yusuf Miller and Sabrina Weddle has stated. It is very important for you guys to have jurisdiction over the medical staff. Also, knowing that my daughter Lisa Serna had died, what the deputies would say, they blamed the medical staff. And so if it's always going to be the medical staff who's is considered more responsible for the inmates' health, because obviously the deputies don't know how to do basic CPR or put our loved ones in a recovery position. I mean, they don't know anything. So I would say yes. They need to be seen, because they're not doing their job. And earlier, a gentleman, Guzman, had stated that he witnessed medical staff passing out drugs. So, something's wrong here. This has to be fixed. It's not right for our loved ones to be neglected and die tortuously. I really do hope that you guys really push the issue and gain jurisdiction over these medical staff. Thank you.
There are no other requests to speak. I do have one request to be read into the record, but it's for item 7B. It was.
Go ahead. It's okay. Yeah, go ahead.
I apologize.
Okay.
My name is Deidre McLeod. My pronouns are she, her. With regard to clerk priorities and goals for 2024, I'd like the board to prioritize input from community organizations with experience in law enforcement oversight and accountability, and set a goal to have just as many public presentations from such groups as presentations from the sheriffs and probation departments next year. Existing CLERB rules and regulations, section 3.6G and 3.6J, establish that board members shall receive training in the community's perspective on law enforcement, as well as training to familiarize themselves with diversity, inclusion, and unconscious bias. A lot of people in San Diego County are doing work in these areas, and you would be doing yourselves and the public a service by taking advantage of their informational expertise on a regular basis in 2024. And that concludes the comments read into the record.
Great. Thank you. Can you keep that in a folder with all the wonderful?
Yes,
Thank you. All right. Number 9, board member comments. Each board member has 30 seconds. Are there any board member comments?
I cede my time to anybody who wants it.
All right.
Just really quickly mention that I have asked that we have at a future meeting, I think we decided maybe December or January, a presentation from probation on how out of custody people who are on probation out of custody are supervised. And I'm hoping that we will be able to have that presentation in the future.
Maybe we can have that for December. Paul, do you think that's doable? Oh, sorry. Of course, that would depend on that.
It would depend on them.
Yeah. See what they can.
Okay, I'll get with senior supervising probation officer Lewin tomorrow morning.
Okay, great. Thank you.
And again, to clarify, you would like them to make a presentation on how folks out of custody are supervised.
Yes, I am not familiar if they meet in person, or it's on the phone, how that works.
Yes, ma'am. All right, thank you.
Great. No more board member comments? Oh, not here.
I would like to reiterate my invitation to Sheriff Kelly Martinez to attend our CLERB board meeting, specifically to speak on the enaction of SB 132. It's already been enacted in the prison systems. I'd like it to be enacted in jail systems. And if she could come, again, this is, I think, my 15th request. I am keeping track.
Thank you. All right, and with that, we'll go to sheriffs and probation liaisons. Curious, is there any? Come on down.
I'll try to make it quick. Thank you for talking about NACOL. I had the opportunity to go to NACOL when I was a sergeant and the CLERB liaison back in 2016 in Albuquerque, and it was a very educational experience. My main takeaway from it was, after having seen all the different community oversight groups around the nation, just how kind of reiterating what Paul and some of the board members said, just how lucky we are. The professionalism of CLERB has always impressed me, and that was just reiterated seeing. So I think we have a very good working relationship, and I really appreciate the quality of the work the investigators do. And so anyway, thank you, Attorney Gross, for your presentation. That was very informative. I just she mentioned something about in 2003, since 2003, there hasn't been too many interviews, and that is accurate. Historically, deputies have been haven't done in-person interviews after they've done the written thing. I will just say part of the process that I don't think she did intentionally, but a lot of times the deputies make decisions after consulting with their legal staff, so our union. So that's part of the equation a lot of times. But I can tell you in recent history, we've had 2 deputies speak with the investigators, and we're always willing to have these conversations with CLERB and the DSA to look at some of these processes. Chair, can you just clarify? You said something about a drug screen. What did you want me to find out? Something about drug talks. I heard you say something about a drug screen at the jail. Something.
Oh, Paul.
I think she's talking about CNET.
Oh, okay.
That's what you would like to learn about if
C-
possible.
CNET. Okay.
Yeah, and then the resources about what your folks do to do drug screening, whatever is publicly available to be discussed.
Okay. I'll follow up with you on that. Like Paul said, I'll be more than happy. If any of you would like to go on a tour of any facility, we'd be happy to accommodate that. I'll also remind you, deputies love to see you out there on ride-alongs. If anyone wants to go on a ride-along, we can accommodate any area of the county, any time of the day or night. You don't have to do the full 12-hour shift. You can just go for a few hours. But I've seen you folks out there many times, and I think it's a beneficial experience to everybody. And last thing, like I said, appreciate all your comments. Just in closing, I can tell you, I've had many conversations with the sheriff, and I know she values CLERB's input, as do I. And you all folks are all a priority. And like I said, I meet with Paul and Lynn regularly, and anything we can do to help you with your mission, that is my job, and I'll make it happen.
Thank you. Really appreciate that.
Yeah.
This lieutenant has done exactly that.
Yeah. Very, very responsive. We appreciate that.
You're welcome.
Good question.
Absolutely.
Yes, sir.
How are the deputies trained to fire their weapons in the line of duty? And how often do they get that training? And what is the standard? If they don't meet the standard, what happens then?
Yeah. So the initial training was in the academy. It's quite a few hours, several hundred hours of firearms training. After that, per the California Peace Officer Standards and Training Commission, I believe it's every 3 years, 2 or 3 years, we have to do what's called CPT, continual professional training. And so every 2 or 3 years, we go through a cycle of firearms update. But as far as qualifications, we typically qualify with our firearms twice a year. That includes all issued firearms, handguns, rifles, shotguns, tasers, less lethal rounds. And if a deputy does not pass a qualification, they're given another chance. If they fail that second qualification, they're essentially given training until they can get up to that standard. It's rare because usually, most deputies shoot on a regular basis, and then if not, the training usually gets them where they need to be. So luckily, I help out a lot of the qualifications. It's rare, but that's typically what happens. If there's some instance where someone just can't cross the qualification period, then that issue is looked at by supervision and personnel on, why they're not passing it. Is it a medical issue and then that's dealt with as a personnel issue.
Thank you. The accuracy piece, one thing, but the situational piece is what, they get that's part of the training as well, correct?
Yes, there's qualifications, but then yes, any training we talk about all aspects of firearms, including threats, timing, reaction time, backdrop, your background, all that stuff. You're welcome. Yes, sir.
Would you agree that shooting skills are very perishable?
Absolutely. That's why they're mandated, that the qualifications are mandated and the peripheral skills are mandated because they are definitely a perishable skill.
How often would the average officer fire the weapon and carry one leading with them?
That's a tough question. I can't speak. I know there's a lot of deputies that are shoot more than others, but because they like to shoot. But the department is the ability to shoot is always available. The range is always open. We're given ammo, so a lot of deputies take advantage of that. But I can't answer that question because everyone's different.
So we have no idea how they keep up their.
I don't, other than the post standards, and if they're not passing qualifications, like I said, which is rare, then that's kind of our indication that they're not keeping up to the standard.
When a deputy engages threat, here's the drive. And I'm gonna date myself all as well. We were told, all right, we generally do 2 center mass, 1 to head, to evaluate. What do they train to say? Do they empty their magazine? I mean, they say from the threat no longer exists.
Yeah.
How are these things going?
Typically the training is, stop the threat. So that could be.
What does that mean? Is that up to the deputy?
Well, every scenario is different, right? I mean, it could be 1 round. I've seen shootings. They're all available online now, where people have been shot 20 times and the threat isn't stopped. So every situation is different. And then there's a lot of other factors at the range. You're looking at a static target. There's no fear, there's no adrenaline in real life. When you think you're possibly going to die, there's a lot of other factors physiologically coming into place. So there's just a lot of moving parts.
Would you agree that very often people will rush to a scene and they'll speed things up, where a supervisor can say, "Hey, hold on," because when you're doing, let's say, felony stuff, all right, things that you want to do, control, safety, tax, and advantage,
Right.
all right. And say an individual at the end of a cul-de-sac. You have a head-on stop and you have 2 other units behind them. Is there any reason to rush forward and tell somebody, get out of the car right now? Instead of saying, the old days, show us from here.
Yeah.
All right.
Yeah.
I mean, do they get credit for getting to slow things down and give the individual an opportunity to process and react?
Absolutely. These are all valid points. I can just tell you from my experience, 22 years on the job, things have changed a lot over the years. Deputies slow down. Our younger deputies are definitely different generation, and they're trained. They have a lot better training than we did 20 years ago. But de-escalation is a policy that's now in place. The training is taught, and deputies are encouraged in training and by supervision to slow things down. I will tell you though too that we're only part of the equation, right? We have to react to what the suspect is doing, and unfortunately, that dictates a lot of the time the speed of things. Not always, but many times, unfortunately.
And generally, when you have felony stuff, you try to have a supervisor there to control the scene, right?
Absolutely. Yes, we'd love to have a supervisor on a felony stop. Sometimes they might not be or they get there in time. And sometimes if it's a slow static scene, but it just depends on, like I said, the cooperation and many factors. But yeah, they're not a bad idea.
No, I want to get back to the old days, when Paul and I out there, it was, couple around, reevaluate.
You're old.
Now, today, when they say, the threat is stopped, does that include emptying their magazine with, how many they have, 15 rounds, 17 rounds?
Typical weapons have 18, 17 and 1, so 18.
One in the chamber, and 17 the mag.
So no, we're not trained empty your magazine till, and that's not a trained thing, but yeah, could it be possible if there's a threat? I mean, it could be possible. But that's not like, we don't say, hey, empty your magazine.
Are officers trained to release their magazine and insert a magazine after they fired, say, 10 rounds?
We are trained on what's called a tactical reload, which I believe you're referring to, where if you have time and it's safe to do so, you can top off your gun. And if you only have a few mags left, if you only have a few rounds left in your magazine. So, but that all depends on if you have a safe place for cover and if you have the time to do so.
Right. And if you fire the last round, the slide can back, locked in place.
Right. Then you have an emergency reload when you have slide lock.
That's right.
Correct.
And the reason that that's happened, not only does the slide lock back, your sight picture changed, right? The sights you were looking over are no longer there.
Absolutely. And then unfortunately, physiologically, when you're in a gunfight, typically a lot of times you're not even seeing the sights because of what your eyes do. And
AGI, your 2 minutes are up.
All right. No, I think Lieutenant Perkins is you're consummate professional. Love it. You did a great
thank you.
job.
I've been a firearms instructor for about a decade, so if I can answer some of these questions.
That's wonderful.
All right.
Thank you.
You got it.
Thank you very much. Any other questions? All right. Anything from probation? Thank you very
you.
much.
Yeah, just real quick. I know everybody's anxious to move forward, but I know we do have a presentation scheduled next month. I'm gonna double check what the topic is. So I'll talk to Paul about that tomorrow, but I know there was something that was in the works following I think the recent meeting with executive staff. I don't know if it's specifically going to address supervision levels, but it might be, it might touch on that, but we'll confirm that. But I believe something is planned for next month's meeting.
I believe you are correct, that there was not enough time. And so it's now December 12th. And I do believe, now that I'm thinking about it, it's the same thing that the vice chair has asked for.
Yeah, we'll confirm that and we'll talk.
Okay, thank you.
We'll talk tomorrow.
Thank you.
But yeah, I appreciate everybody's time and energy. And I think Paul and all the investigators know that we're happy to answer any questions we can. Our department is, filled with different subject matter experts. So if I can't get the answer, if I don't know it, I will certainly get it within a reasonable amount of time.
Great, thank you. Did you have a question?
And I think it's fair to say, and I think it's appropriate to say that many times SPO Lewin is simply the messenger. So
We understand.
we understand that as well.
We understand that.
Yeah, but whereas the sheriff has DIS, Division of Inspectional Services, and a whole team of folks, in our department, it's essentially myself. So happy to do it. It is a collateral duty for me as a IA investigator, but we've been working together a long time, and it's kind of like it's important work. And when I left my position not too long ago for a period of time, when I came back into it, I was eager to come back into the fold with CLERB. So I believe in what everybody's doing and happy to be a part of it too. A small part, whatever part I can play.
Thank you very much. We appreciate it.
Thanks.
Okay, and with that, we will take a 5-minute break, and then council, if you could read us into closed session. Yeah, if you could read us now, and then we'll take, I'm sorry, I said that backwards, didn't I?
Yes, thank you, Chair Delaney. On tonight's closed session agenda, public employee discipline dismissal release pursuant to Government Code Section 54957. There are 13 cases for summary hearing as described in the agenda, and that is your agenda.
Thank you. 5 minutes.